All right, please be seated, everyone. And I hope parking was okay today. All right, sir, you're still under oath and state.
Yes, ma'am. Just a few more questions. Mr. Kirkbride, did you give anybody permission to take your truck or your trailer or the contents of the trailer or the truck?
No, I did not.
Okay, and I'm going to show you what number. Your Honor, may I approach?
Yes.
Recognize anything in what I've just marked as State's Exhibit 85?
Yes, this was when we were called out to recover our trailer after they found it parked in a neighborhood. And that's me standing there with my back to the camera, kind of looking at the remnants of what was left in that trailer. So what's in that trailer at this point is just wrapping paper that was used to wrap up things. There was a tub, garbage, basically. It was just trash and stuff that was left in there from the wrapping for our items, but there was no valuables in there. The only two things that come to mind that were found in there was a couple of pictures of our kids when they were young. They were just on the floor, just randomly. And then there was a certificate of Rachel's grandmother. She's a pure Yaqui Indian, and it was like a, I don't know what they call them, but it was basically a certification. It was in a frame. And of course, it wasn't in the frame. It was just wadded up and thrown on the floor. So,
Your Honor, I offer Exhibit 85. This is tax notes.
All right, State's Exhibit number 85 is admitted.
Do I have permission to publish this, Your Honor?
Yes.
So was it nighttime when you went out there to meet the officer?
yes, we were called before midnight when they recovered it. And that was shortly after midnight when we actually got there on the scene.
And is this you?
That's my back.
And is this your trailer that you're standing in?
Yes, it is.
And when you packed it, was it in this condition?
Oh, absolutely no.
Was it full? Was it packed full when you packed it?
It was so perfectly packed. It was side to side, top to bottom, and all the way from front to back. There was absolutely no room in that trailer left. I was even sliding some of my vintage signs and such on top of the load, on top of the boxes.
Do you know the approximate dimensions of the trailer?
It's a 24-foot enclosed trailer, approximately 7 feet wide and about 8 foot tall.
And that was full of your property?
Yes, it was.
And among the items that were stolen, was clothing stolen?
Yes,
Were electronic items stolen?
yes,
Were household items stolen?
yes,
Tools?
yes,
Were toys stolen?
yes,
Were sporting goods stolen?
yes,
Were weapons stolen?
yes,
Was a pistol stolen?
yes,
Were fashion accessories stolen?
yes,
Was jewelry stolen?
yes,
Were magazines stolen?
yes,
Were books stolen?
yes,
Were paintings stolen?
yes,
Were artwork stolen?
yes,
Were collectibles stolen?
yes,
Were vintage movie items stolen?
yes,
Did you have some antiques stolen?
yes,
You have some motor vehicle parts stolen?
yes,
You have military collectibles stolen?
yes,
You have US currency stolen?
yes,
Did you have food items stolen?
yes.
I passed the witness, Your Honor. Thank you.
All right, defense.
Mr. Kirkbride, I understand from your testimony that you've been in contact with various people involved in this case since the beginning. Is that correct?
Yes, that's correct.
Law enforcement,
Yes,
the district attorney's office.
yes.
So as part of that, following, the status of the case and wanting to know what's going on, are you aware of an indictment being returned against Mr. Lozano?
Not specifically. I don't think my mind would pull it up as an indictment.
Well, at some point you were told that somebody got arrested, correct? And I'm assuming, well, I'm not going to assume. Were you informed of what that person was being charged with?
Yes, I was by Detective Hodge. Crime, I think initially he was talking over 200,000, then later it was a crime because our numbers were so much higher, over 300,000.
And are you aware that in the indictment, it lists categories of items that were stolen?
Yes, I am.
Basically, the laundry list that the state just reviewed with you.
Yes, sir.
Do you agree with me that the truck is not included on that indictment?
That is correct. I don't believe the truck was.
As well as the trailer?
I'm unclear on that.
Okay. But if those items are not in the indictment, do you understand that means that issue of whether or not he stole those two items are not before this jury?
Objection. I think that calls for a legal conclusion, Your Honor.
Not sure.
That'll be overruled. You can answer the question if you know.
The best I can answer is that my F-350 dually truck was stolen along with my trailer and all my contents in it and everything that was inside of the truck, which was a lot. I had it inside the camper shell of that truck, where I had a newly rebuilt motor for the rat rod or the 47 or 37 truck that I had that we were pulling behind the Penske truck. And I had a transmission. It was on a pallet and was pushed forward into the pickup truck. And then also in the back of that bed was documentation, things that were important paperwork wise. We kept it in that location primarily.
What I was trying to get to, Mr. McBride, is whether you acknowledge or agree with me that what the issue before the jury is the value and of all your belongings, that some were recovered and some were not.
Yes.
Okay. Yeah, approach, Judge.
Yes.
I want to start with talking about State's Exhibit number 84. When did you prepare State's Exhibit 84, Mr. McBride, as best you can remember?
Right away, we were dealing with USAA, our insurance, and they tasked us with giving them a list of everything that was stolen, which was an incredible task to even take on, but we did. And so it was approximately 3 months after the theft is when we had a concluded list of everything that we can recollect that was stolen, that we had pictures of to help reconstruct it. And so approximately 3 months after the incident, we started putting together this list. We probably did 4 or 5 revisions of this list in the sense that we were adding more items to it until USAA said, okay, that's all the items. And then they put it in their own spreadsheet and kicked it back to us. And that's when they started doing the value adjustments on everything.
Now, you've indicated on this list from State's Exhibit 84 that this is a partial list.
Correct, because this list was given to the detective, and ultimately to the DA early in this case. This case, what, 3 years, 3 months now since the incident happened. And when I gave this information, it was because it was being asked of us, hey, so what was taken? So we gave them what we had at the moment.
Okay.
That's this list. And we did add more.
Excuse me, sir.
I'm sorry.
I'm going to have to ask you to listen to the question and just answer the question.
Okay.
So, Mr. Kirkbride, my question is there a final draft of this list? That's the most updated version.
Yes.
Okay. Do you know where that list is?
Yes. I gave it to the DA. It was the list that USAA published back to us, listing everything.
Now, are you talking about the list that was furnished just a few days ago?
Yes, sir.
Yeah, approach Judge.
Yes.
Let me go through Mr. Kirkbride, make sure I got the right one. Yeah. Well, I'm looking for it, sir. Basically, that list has all your final listing in your claim to the company for reimbursement of lost items, correct?
Yes, sir, that is correct.
And if an item is on that list, that means you never recovered it, correct?
That would be correct.
So because you would not have submitted a claim to USA for things that you did recover.
That is correct.
And the things that you did recover are all those pictures that we went through yesterday. Is that fair?
That'd be fair.
Okay.
And could I have parties approach briefly, please? And we're not on the record. So, sir, this is where we are. I don't know where this question is going to lead. People are always surprised that I learned the facts or proposed facts of a case as I'm listening to it, unless there's been a motion to suppress. So I'm hearing this just as the jurors are hearing it for the first time. I don't know where the question is going to go. However, if there's allegations that a claim was submitted to USAA, USAA paid that claim, and then maybe items were recovered, but there was no report back to USAA saying, oh, by the way, you paid me, let's just say, for example, a pencil. You paid me for this pencil, but I've recovered it. So here are your funds back. Or either it's included in a list before USA makes a payment, and then the item is received back and USA isn't told, but USA paid for that. That could result in jeopardy.
And I'll just say this, the items.
Well, no.
Oh.
I'm just,
Yeah, no,
I don't want
They were
you,
excluded.
yes,
but-
here's the thing. I don't want you to give me any information about that. I just want to put everybody on notice with that. So if that is the case, which I don't know if it is or not, then you may need an attorney to instruct you on the consequences, the potential consequences for that. So if that is not the case, then we will proceed. But if that is the case, then he's probably going to need an attorney. I don't know.
Judge, I don't intend to accuse of anything, but because we got this list just a few days ago, I have to cover those bases.
No. I understand. And I understand that you're just going to ask questions,
That question was asked.
but
Those are excluded from this,
that's where we are. Okay.
Were they excluded from this initial list or from the final?
from the final list.
All right. Thank you. I always want to make sure that everybody has all the information they need.
Yeah, I'm good on all that.
All right. And I will tell you, you're not the first witness that I've had to give that instruction to.
Okay.
All right. If that is that, Deputy Mejia, can you let Deputy Laura know we are ready to bring the jurors back in? All right, defense.
So, Mr. Kirkbride, the exhibit number one is some generic documents involving your insurance claim, correct?
Yes, it is.
Okay. I've now given you defendant's exhibit number two, correct?
Correct.
Is that the final listing that you gave to the insurance company of items that you never recovered that were stolen from you in order to make a claim?
That is correct.
And is it fair to say that in that list, you assigned the values you thought the items were worth?
That'd be fair to say.
Okay. And then the insurance company later came back and told you what they thought the value should be.
Correct.
And so that's a good summary of the dispute you had with the insurance company, obviously unrelated to the theft, but that's what we'd be looking at in exhibit number two, correct?
That is correct.
So in this case, when he's charged with over $300,000, it's because by your listing, it exceeded $300,000.
That's correct. I think it came up to 451,000, and it was all documented and quantified with research, comps, documentation, all given to USAA. They don't give you the full value. The insurance company works their formula in such a way that they depreciate everything, when a lot of the items should have actually appreciated because they were collector items and antiques. That's the
So-
rules.
Would you agree with me also that included in that figure is the vehicle
One moment.
somewhere?
Yes, I see the minus $19,604 is all they gave me for my vehicle. So that'd be minus that.
So just so the jury is aware, in the $400,000 figure that you submitted a claim for, how much did you submit a claim for in regards to the vehicle?
The vehicle was just submitted as a total loss because it was stolen and not recovered. And they do their valuation on it, which I disagreed with too, but that doesn't matter. And they gave me 19,600.
So you're saying
Or-
that the 19,000 is not in the $400,000 figure?
From what I can see, sir, no, it is not.
Okay, fair enough. So we have a listing of your final accounting of all the things you thought you lost, and granted, you did tell us yesterday you remember some things after the fact, but that's the final list of all the items, correct?
Correct.
It appears that all of that is personal property that was inside the trailer, correct?
That is correct.
Okay. Now, my question is there a list of recovered property?
There is no list.
Okay. So when the law enforcement returned the items to you, was the manner of accounting for what was returned basically the pictures we saw yesterday?
Yes, but not all of that made it back to us. And yeah, not any of it was, it wasn't the items that were on the USAA, because keep in mind, we got our trailer back and our possession back a month after the event. USAA and us dealt with them for over a year. And that was certainly the dialogue that was going back and forth between our final tier adjuster and us, accounting for the things that we felt that we got back that were, you know,
And
not
make
on
it
the
clear,
list.
Mr. Kirkbride,
Yeah.
we're not gonna go through and try to
Okay.
make an accounting and make it all matched. I mean, that's an impossible task. I'm just trying to figure out if there's a third list of recovered items, so that we would know between the list of all the things that you lost, how much was recovered versus how much was never recovered.
No, there is no specific list.
Okay, so, and my understanding is you weren't here when they recovered those items, is that right?
I was not.
Okay. So when the police found things that they thought belonged to you, they contacted you, correct?
That is correct.
Then you made arrangements to use your actual trailer to try to recover whatever you could.
That is correct.
Okay, and somebody besides law enforcement on your behalf was there to assist in that process?
Yes, the person that had it stored at his house.
And so are you even aware of what was the process to document what was put in the trailer? Or was there no effort to do that?
I'm not sure what law enforcement did. All I know is that I was contacted that they found the location where our stuff was, and I got a few photographs from the detective asking, are these your items? And had my name on them. I said, yeah, those are our items. And what he did after that, I'm completely unsure, other than he had a group of folks, I guess, assist in working with the lady that was at the house to kind of delineate what was theirs and what was ours. And it just basically got thrown into the trailer and sat in Texas until I could arrange transport. Actually, I should take that back. We actually flew out to Texas once it was back in my friend's the backyard. And we kind of combed through everything, and a whole lot of that just got thrown away right away, but there wasn't much left. It was either broken, incomplete, or water damage from being left out.
And is it fair to say the water damage mainly affected paper items?
Paper items, clothing items, some artwork that, you know, it was no longer worthy of having.
For any reason, did you think to document what you threw away?
No, not at all. To me, it was just garbage.
Do you have any reason to believe that items that belong to you stayed at the location of the recovered items?
Well, I will say that looking at all those photographs, there was items that I don't recall ever seeing again since the theft that were in and around the area, but there were few. It just, I was able to single in. I can't even recall them right now. I'd have to go through all the pictures again, but there's some items that we didn't recover. It looks like maybe a box of photographs and a few other things.
So would you say the majority of the things that are depicted in the pictures you did in fact get in your possession?
I'll say yes.
And then after that happened, some of those things you either discarded or felt they weren't salvageable?
Correct.
Okay. And so did you actually take some of those things back to Florida, or what happened next?
Myself and Rachel spent a day taking everything out of the trailer, laying it on tarps, trying to salvage what we could, and then repacked it back into the trailer. And then we flew back home, and then I arranged a transport company to tow the trailer back to our home, and that was probably, gosh, 7 months later, 6 months later.
Okay.
It was.
And so was it never suggested to you by law enforcement that there needed to be an accounting of what was recovered at that particular location?
Not to me.
Okay. Because so you would agree with me that we have no, other than the pictures, we can't create a list of what was located at the location where these items were recovered?
I didn't receive any lists, and I didn't create a list. I'm not sure what the officers did as far as documenting what they found, but I never received anything.
Okay. So let's go back to so defendant's exhibit number 2, you agree was your final listing of things that were never recovered, correct?
That is correct.
And that list totaled up to $400,000.
That is correct.
And what did you ultimately settle that claim for with the company?
The 231, 419 is in the column 3 after they did the depreciation against it.
And Mr. Kirkbride, I think we're all aware and clear at this point that you don't agree with that figure. But nevertheless, you signed releases saying that you agreed to accept that to settle the claim that you made.
That's correct.
Now, would you agree with me that you had other remedies to continue to pursue that claim?
I'm unsure what you mean.
You could have sued the company and said, no, I don't agree. I want my $400,000.
that never occurred to us. I mean, we painstakingly, we were pretty tore up from this whole event. So the whole year of just trying to get that done, USAA claim done, was we were done. We were on the ropes. We were done. We had no fight left in us. We said, okay,
Understood.
we just want to get on with our lives.
But would you agree with me that the release that you signed included language that suggested that you agreed that the value in fact was 200 and whatever the number was?
Yes,
So all those items that are on the claim that you got paid for, do you have any reason to believe that any of those items were ever located at the same location as the other items that were recovered?
are you talking the items that are that were? I'm unsure what you're saying. There's the vast majority of everything was gone forever. So what was found at this site was picked through basically garbage, things that didn't mean anything to whoever was picking through it. All the valuables were gone. So what we recovered was some clothing items with mildew on them. Got one of my mini bikes back, got a kayak back. We had some remnants of our collections, most of which the glass was broke. So those were just discarded while we were in Texas. And the list kind of goes on and on from there, but it was. So maybe I'm not sure or clear of your question.
I'll ask a couple more, maybe we'll clear it up. We know from the pictures and from the officer's testimony and the person that went over there on your behalf, we know what was actually recovered from that scene and put in the trailer, correct?
Correct.
Do you know of any evidence that suggests that all the items that were never recovered were ever at that scene?
No.
In other words, let's hypothetical.
Other than seeing hundreds of cardboard boxes that were emptied and strewed about the yard and plastic tubs that had the tops open and strewed about the yard, I can only deduct that our stuff was in them, but no.
Well, I think in your testimony yesterday, you said something along the lines of nothing of any value was really left, or something like that. You recall saying that?
Yes,
So was that basically your way of saying somebody went through and found the valuable things and those things never reappeared?
that is correct.
But would you agree with me? We don't know who that somebody is.
Yeah, I guess I could agree to that. I mean, if it's just a yes, no question. But I think that's why we're here in court. We have the person here.
Well, and I understand where you're going with that, sir, and your speculation and your things that you could deduce. But this goes back to my initial question, is he was never charged with the theft of the truck.
Object to the form of the question.
All right, that'll be overruled.
I had to get my trailer there somehow. Had to get the camper shell off my trailer somehow. Or off the truck, I should say.
That's what, sir.
Right, state.
That's the witness, Your Honor.
All right, is this witness excused?
Judge, before he goes, I'm going to offer defense exhibit number 2.
All right, any objection to defense exhibit number 2?
Can we approach, Your Honor?
Yes.
Yes, Mr. Kirkbride, apologies. Apparently, I didn't ask clear enough questions, but let me see if I can do it this time. You suggested that the final version of the list of all the things that were stolen from you was encompassed in defendant's exhibit number 2, correct?
Correct.
And the numbers on the very left-hand side of the columns, there's various columns, very far left is the number that you ultimately decided was the value for each item you're making a claim for.
That is correct.
And you personally came up with those numbers by doing research, trying to recall what you paid for the item, that sort of thing.
That's correct.
And in fact, you even did research on what the value might be because some of the things were collectible and they might actually increase in value.
That's correct.
So all those numbers are your numbers,
Correct.
put together by you and your spouse and the research.
Yes.
And in fact, when you made the claim to USAA, they ask you, do they ask you to attest to that? Do you have to submit a sworn list, or they just ask for a list?
They just asked for a list.
And how do they,
And we submitted photographs,
Okay.
a lot of photographs.
how do you go about submitting that? Is it a form that you fill out, or you just send them what I'm looking at there?
No, they were uploaded and sent to the tier adjuster, along with any receipts that we did have at the time. The photographs were a lot of the ones from, again, I would, let's say you were at my house, you took a picture of me, and I got a cabinet behind me, and I take that picture and I scanned it, and then I blow it up, and I'm going through every item that I can find in the house, and then, okay, that's this item here, and then what is that worth? This is what we feel it's worth. They had a high, low, usually find a high, low because of condition. We always were very conservative, and that's what we would add to the list. And that painstaking process was done for everything.
Ultimately, how many items are on that list?
Oh, gosh.
I think they're numbered on there.
Okay, that helps. There's 306 columns, but you should note that there's numbers like 42, 16, 45. I mean, there's a bunch of like in one category, there would be like under the toys. Let's see if I can find a couple here. Like several camping gear items. There was 20. And then I had to do a unit cost, $150. Again, an average of our camping gear. And then that got put into that column. So even though there's 306 line items, each line item has a quantity associated with it of a particular collection. It was just too tedious and too much, and USAA really didn't want that much detail. They just wanted us to state and then give them the average cost. So if I had I had a 10 toy motorcycle collection, pretty vast collection, along with Hubleys and Auburns, just an antique motorcycle collection, toys. Okay, Hubleys and Auburn, they're just name brands from the 50s. They were just cool little motorcycle plastic toys, along with 10 toys. That collection of toys would range from, I think, $40 all the way up to $800. So when I had put them all together, and this is with the instructions that we had from the USAA, I had to do an average. So I had to average and then put a unit cost for each toy. Like if there's 25 of them or 30 of them, I would have to say the total value is this, the average cost, if you divided it, is this. And then that's how they had us given the information.
So to understand your explanation correctly, the 50 toys would be only one line item out of the 300.
Correct. Like this is a kind of a silly one, but over 300 Blu-ray movies. That's just one line item, but there's 300 of them. And so I had to do an average cost. Okay, $10 each. And then it came out to 3,000. That's what the center line is. And then they do their adjustment. They knocked off 750, gave us a credit of 2,250 on that one line item. And the paperwork shows how that was done.
So would you agree with me, Mr. Kirkbride, that the vast majority of things were not recovered, and what you did recover was a small percentage?
That is correct.
Pass the witness judge, and I'll re-offer defendant's exhibit number 2.
All right, any objection to defense exhibit number 2?
No objection, Your Honor. We don't have any more questions.
All right, defense exhibit number 2 is admitted. Is this witness excused or subject for recall?
Excuse, I think, Judge.
Yeah, excuse, Judge.
All right, the rule has been invoked. What that means is you're not allowed to discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state and the defense. All right, you may step down. State, call your next witness.
Your Honor, the state calls Detective Vincent Gonzalez.
If you'll state your name for the record, please.
Detective Vincent Gonzalez.
All right, if you'll make sure you keep your voice up so that the members of the jury and the court reporter can hear. All right. State,
Detective Gonzalez, who do you work for?
City of San Antonio Central Police Department,
How long have you worked for SAPD?
approximately 22 years now.
And what are your current duties with SAPD?
Currently, I'm assigned to the Vehicle Crimes Unit.
And what's your role?
I'm an investigator detective.
I want to draw your attention to December 4th of 2020. Were you working on that day?
Yes, I was.
And did you have to respond out to go process the scene?
Yes, I did.
What did you have to go process?
I came in as a recovered stolen vehicle, which ended up being a trailer.
And do you remember what time did you go out there?
I know it was after midnight, I believe, roughly. Sometime it was late at night.
And would it help to have your report in front of you? Refresh your memory.
For the time, yes. Sorry.
Sir, I want you to, you can't read directly from that, but if you need your memory refreshed, just take a moment, read and answer the question, okay?
Okay.
So roughly what time did you go out there?
So about 11:40 p.m.
And was there another officer that was already at the scene?
Yes, the officer that was assigned to the call, Officer Tackett.
And just for clarification, what was the SAPD case number for this case?
For this case, it's SAPD 202302559.
And is that the case number that just sticks with the case throughout the entire investigation?
That's the case number that should be attached to it at all times, yes.
So while you were out at the scene, what did you do in processing the trailer?
I arrived at the scene, I photographed the recovered vehicle in the condition it was found. And then I turn around and search for Latin prints and process for the Latin prints that I located.
Yeah, and explain to the jury, what's a latent print?
A Latin print is an impression left from your fingerprint onto a smooth surface.
And are fingerprints left on every single surface?
Not on everything, they're usually left on a smoother type surface like glass or metal.
And what about palm prints? Is that something you would also process?
Yes.
And did you also take photographs on this night?
I did.
First defense. I'm showing you what's been marked States Exhibits 86 through 103. Do you recognize these photos?
I did.
And what are these photos?
These are photos that I took that night.
And are they true and accurate representations of the trailer and what you observed?
Yes.
Have they been altered in any way?
No.
Your Honor, state would offer states 86 through 103, and I'll tender to defense for inspection.
No objection, Judge.
all right, States Exhibits number 86 through 103 are admitted. Granted.
So when you took these photographs, do you remember what was the condition of the trailer?
It was empty. The trailer was abandoned on a street. And most of the items were gone from inside the trailer.
And you said you also processed this trailer for prints. Where did you find prints?
On the exterior side, on the front exterior, right there where The tongue is at usually where you would connect or disconnect the trailer.
And what's the process of obtaining fingerprints?
We take a black powder, non-magnetic, spread it over the area that you want to dust and search for the Latin print. And then we'll take a transparent tape, put it over the area you want to look the print from, and then remove the impression from that way, and then put it in the back of a card, an index card.
And then what would you do with that card once you've obtained the prints?
Once the prints have been obtained, we submit the prints to our, we had a file box, submit them in there, log it in. It would indicate the location, the case number, the exact location where we found the prints from. My name would be on it, and approximately the time and date.
And where do you leave these prints?
They would get submitted to the for the fingerprint processing. We have a box that they come pick up. It's like a lockbox where we submit our fingerprints to.
What's the purpose of it being submitted to a lockbox?
For the custody, chain of custody, so that way, that's the last time that it gets added, no one else can get it, other than the person with the key.
So I'm gonna approach, because you brought something with you today, is that correct?
Yes, sir.
And now you didn't have custody of this before today.
Objection, Arlene, the witness.
All right, that'll be, I'm sorry, once an objection is made, remain silent, and then I'll make a ruling on that. Defense, what is your objection?
Leading the witness, Judge.
All right, that'll be sustained.
What did you bring with you today?
I brought the Latin print cards that I took of that night.
And did you have this in your custody before today?
I did not.
Where did you get these from?
From a fingerprint team member who works in that department.
Now I'm gonna mark this envelope as States 104. Now, what is inside States 104?
3 index cards of fingerprints that I lifted that night.
And how do you know that the cards inside States 104, that they were the prints that you lifted?
They're in my writing with my name on it.
Did you put any case information?
It's got the case number on it. It's got the location and time. A quick brief drawing on it that I put to show where the prints came from.
And inspection, States 104. Write that down though. So, Your Honor, state would offer States Exhibit 104 and its contents. It's 3 latent fingerprint cards.
May I take them over there, Judge?
Sure.
Have you actually looked and see what's inside that envelope?
Yes,
Like, I mean, like right now?
yes,
Okay, and so you're satisfied that those are the ones you took?
yes.
Okay, no objection. Judge.
All right, State's Exhibit number 104 with contents is admitted.
And what was the case number that's written on the card?
It's on the top of the card envelope or actually an card.
Both.
So it's 20230259, which is the same one that's on the cards right in the corner.
Ask the witness.
No questions, Judge.
All right, is this witness excused or subject for recall?
Excuse, Judge.
Excuse your Honor.
All right, the rule has been invoked. What that means is you cannot discuss your testimony with anyone. You're only allowed to speak to attorneys for the state or the defense. Do you understand?
Yes, ma'am.
All right, if you'll step down, Diana, do you need to sign? Okay, all right, thank you. All right, state, call your next witness.
Your Honor, we call Denise Serenil.
State your name for the record.
Denise Serenil.
All right, and if you can make sure you keep your voice up so that the members of the jury can hear and the court reporter can hear. All right, state.
Good morning.
Good morning.
Could you tell the jury what you do for a living?
I am a latent fingerprint examiner.
For who?
I work for the San Antonio Police Department.
And how long have you been doing that?
Latent examiner, 7 years,
How long have you been employed by SAPD?
30 years.
And what are your duties as part of your job?
Part of my duties is receiving latent prints, examining them for legibility, clarity, signing them in, showing that I did receive a particular jacket of latents.
And can you sort of briefly describe to the jury what's a fingerprint, what's a palm print as part of your job?
A fingerprint is an impression left on the surface by the friction ridges of each finger and thumb. A latent print is unknown, unseen, and needs some type of further development to be seen.
And did two people ever have the same fingerprint or the same palm print?
They do not,
Okay, you've never heard of that as part of your work?
correct.
Okay. What's an inked print? Can you tell the jury when you refer to an inked print, what are you talking about?
An ink print is a rolled impression of each of the friction ridges of each finger and thumb with black ink on a suitable contrasting background.
Okay. And all right. So when you examine a set of prints as part of your job, where do you pick up the prints from?
We, on a daily basis, we pick up latents from the central from the central station. That's done on a daily basis. And there are 5 examiners. We're each assigned to a district of the city. So this is how I obtain what I am working on.
Okay. Can I approach the witness, Your Honor?
Yes. Oh, sure, you can adjust it however you would like.
Oh, it's
Is it too high?
no, it's too back. Is that
Oh,
okay
you will
with
have to lift it up and push it over the
That's
hump.
fine. I'll just take it.
Thank you.
I'm going to show you what's been marked and admitted as State's Exhibit 104. Do you recognize this?
The latent jacket?
Uh-huh.
Yes.
Okay, and how do you recognize it?
This is what I worked on. It has the date I received it.
Okay. And did you make a report as part of your work on this case?
I did,
Would it help you to have that in front of you to refer to?
sure.
I'm going to hand you that. Can you go ahead and open up State's Exhibit 104 and tell the jury what's inside that envelope?
There are 3 latent cards.
Okay, can you kind of show them? Yeah, let me see so we've got like sort of a front and a back here. Can you describe to the jury what's on the front of these cards?
The front of the card is the actual latent that was lifted.
And then what about on the back of the
The
cards?
back side is, it has the location, the latent was investigation. It has the latent print obtained from. It has the individual who obtained the print. It has the date and the time.
And so as part of your work on this case, did you examine these prints?
I did.
Okay, and did you, we've got 3 cards here inside of State's Exhibit 104. Did you come to any conclusions about any one of these 3 prints here?
I came to the conclusion that they were legible.
Okay, and so once you determine that they're legible, what do you do next?
I enter them into the APHIS system.
Okay, and can you describe to the jury, what's the APHIS system? What does that mean?
APHIS is the automated fingerprint identification system. It's a tool to help narrow the search of a print.
Okay, and so what happens when you put one of these prints into the APHIS system?
What I do is, you want me to do the step-by-step of how
Sure,
to?
yeah, just to kind of explain how that works.
I capture the image of a latent, capture it, and then Once it's captured, it will send me to another screen.
Sorry, when you say capture it, do you scan it into the
Take
machine?
a picture.
Take a photo, okay. And then what? I'm sorry, I didn't mean to cut you off.
I position it to where I feel I'm gonna look at it. Clean it up, and what I mean by clean up is if there's any smudges, I'll block it. And then I'll come to the point where I am going to put my action points, where I'm actually gonna mark my points of what I'm gonna look for.
Okay, and so what do you mean by action points? What you're looking for? Can you explain to the jury how that works?
Yes, if I may.
Yes.
Action points,
So for purposes of the record, you have a demonstrative here
Yes,
that
I
you're gonna
do.
show to the jury? Okay.
action points could be a
And-
dot.
Excuse me. And if you need to step down, ladies and gentlemen, if you're not able to see, if you'll let them know, and they'll step down.
You want,
Yeah, if you could, I can display it here. Is that okay, Judge? If I can display it?
Yes.
All right, so can you kind of walk us through what you mean by that?
so what I'm doing is when I'm getting my latent, getting ready, what I'm doing is I'm marking, this is what we call action points. It could be a dot. This is what we call an enclosure. Like I mark 2 points here. It could be, I'll go 1, 2 ridges down. Here's another action point that I mark. If I go over to another ridge, I have 1 dot here and I have a ending ridge here. These are my points. This is what I am looking for in a latent.
Okay, and that helps you identify, that helps you match up.
It helps me, yes.
Okay, and so you took these fingerprints, you put them into the APHIS system. What happened next?
I launch it into the state database and the FBI database,
Okay,
and it searches.
mhm. And what happens next?
I'm sorry.
What happens after you?
After I launch it, I wait for my candidates to come back.
And is this the return that you get in this case?
Yes,
And so did you come to any conclusions after you put the information into the APHIS system?
I was given 20 candidates.
Yes, ma'am. And did you get any matches?
Yes, I did.
And who did the fingerprint match to?
It matched to Aracon Jose Lozano.
Okay. And you were here earlier in the week, right? You were here in the courtroom?
No.
Earlier in this week, did you take a fingerprint from somebody?
Oh,
here?
yes, I was. Yes,
Okay. And did you bring that with you?
yes, I did.
Okay. Let me see that for a second. I'm gonna throw a exhibit number here. Daniel, 105.
Yes.
Okay, and so I've just marked this as State's Exhibit 105. Do you recognize this?
Yes,
And how do you recognize it?
because these are the prints I took yesterday.
Okay, and so what's on the front and what's on the back here?
On the front is what we call the 10 print. These are the fingers and the thumb.
So don't show it to the jury quite
Oh.
yet here, but so on the front, you've got what do you have on the front there? You have fingerprints?
I have the fingerprints.
And then what's on the back of that?
Back is the palm prints.
Okay, and you took these fingerprints?
Yes, I did.
And who did you take them from?
From the individual.
Can you
Um,
identify them?
He's wearing bluish grayish shirt.
Okay, and can I see that document? Let me see that here. Your Honor, I offer State's Exhibit 105.
All right, State's Exhibit 105 is admitted.
And so, could I publish this, Your Honor?
Yes.
Okay, so, explain to the jury how these, there we go. So what are these two rows here?
What are those two?
Just the, like, going this way, what are those prints of?
This top part is the right hand. The second part here is the left hand. This is what, these are what we call road prints. Where I got a black ink and I wrote each individual finger.
Okay, can you show me on my finger? Just to give the jury an idea, if you were gonna roll my index finger here, what would you do? If there was ink on it already?
Okay, there was already ink on it.
Uh-huh,
What I do is I roll it from side to side,
uh-huh.
each finger. I do the following with the rest of the fingers.
Okay, good deal. And let me show you the back of this document here. So on the back of States 105, what are those there?
Those are the left and right palm prints.
Okay, so if you inked up my hands, how would you get those onto a piece of paper like you did
I
there?
would ask the individual to close their fingers.
Mm-hmm.
I would hold on to their thumb and I would press down. Get much detail as I can.
Mm-hmm.
And I would do the same to the other palm.
Okay. I'll give this back to you. See that real quick here. So in this case, you had in States Exhibit 104, there's 3 different prints here. Did you put all of these into APHIS?
With the palm, yes.
And which one is that one? This one? Okay. And so this is the one, I'm gonna mark this as 104A. And so, Your Honor, I offer States Exhibit 104A.
Objection.
All right, 104A is admitted.
So this is the print that you received. And you compared that, this is the print that you put into APHIS.
Correct.
And you got the match from this print in APHIS, right?
Yes.
And then from these prints, did you make any determination about States Exhibit 105 and whether it came from the same person as States Exhibit 104A?
Yes.
And what was that conclusion?
They were one of the same.
So these prints came from the same person who left these prints.
Yes.
Okay. Do you have to get a certain amount of points to call something a match?
In-house is 7. For the APHIS, it will be 10.
Okay, I pass the witness, Your Honor.
No questions, Judge.
All right, is this witness excused?
Yes.
Yes, Your Honor.
All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state or the defense. All right. Recess. Then we're going to come back and we'll be back at 10:30. Remember my previous instructions. Everything that you need to know about this case is to come from
Inside.
Yes, all right. Everyone, please rise for the jurors. State, call your next witness.
Patrick Knocker, stand.
If you could state your name for the record, please.
It's Patrick Knocker.
State.
Detective Knocker, who do you currently work for?
Bear County Sheriff's Office,
How long have you worked for the Bear County Sheriff's Office?
29 years.
And what are your current duties with the Bear County Sheriff's Office?
I'm a detective with the Auto Crimes Unit.
And so what sort of crimes do you investigate?
Burglary of vehicles, stolen vehicles, unauthorized use.
And how long have you been in that department?
About 7 years now.
And before that, what did you do?
I worked white collar crime.
And so I want to take you back to December of 2020. Where were you officed out of?
San Antonio, Police Department on the academic court with the Regional Auto Theft Task Force.
And what was the Regional Auto Theft Task Force?
It was a combined unit between San Antonio Police, Bear County, and DPS.
And what was the purpose of this task force?
Resources and intel. We'd get a lot more intel working together on all these car burglars and car thieves.
And so how closely did you work with members of San Antonio Police Department?
Very well. We were in the same office.
How far away would they be from you?
Some would be right next to me.
And what type of cooperation would happen? What would you guys pool the resources?
Well, we had our systems, our database that we could check. San Antonio had theirs, so we would go back and forth.
So were you familiar somewhat with some of the cases that they were investigating?
Yes.
And so I want to draw, again, your attention to December of 2020. Were you in contact with Detective Hodges with San Antonio Police Department?
Yes.
And did Detective Hodges ever inform you of the case that he was?
Objection, Your Honor, hearsay.
All right, that will be sustained.
And Judge, may we approach on that?
Yes.
Now, Detective Knocker, how closely, would Detective Hodges speak to you about investigations that were currently ongoing?
Yes.
And what type of information generally would he relay?
Normally, if one of his cases would spill out into the county, then he would get either myself or the other two detectives information on it.
And would that kind of happen vice versa, where if one of your cases was in the city? in
Yes.
this Jurisdiction.
Yes.
And so did you ever go out to a scene on December 22nd of 2020?
Yes.
And do you remember what was the address of the location you went out to?
13,000 block of Greenwood.
And what city was that in?
I think it's Atascosa.
But that's still in Bear County, is that correct?
Yes.
And why did you go out there?
To do a knock and talk.
And explain to the jury, what's a knock and talk?
It's basically when we just go out and knock on the door and see if we can't speak to the resident owner.
And did Detective Hodges ever communicate to you why you were going out to that location for a knock and talk?
Yes.
And what was his reasoning?
He said he had got a print
Objection,
hit.
Your Honor, hearsay.
All right, that'll be overruled. You can answer the question.
He got a print hit on a recovered stolen trailer.
And so who accompanied Detective Hodges out to this location?
I did.
Was there anyone else there?
I had called for two patrol deputies.
And so on this day, when you conducted this knock and talk, what happened?
As we arrived, Detective Hodge went to the front door. I sent the two patrolmen to the back, and then I stayed over on the right-hand side of the residence.
When you were approaching this residence, did you notice anything that you could see from the front yard in the backyard?
Oh, yes.
What did you notice?
There were chopped up cars. There was a bunch of property laying in the backyard.
And was a warrant ever obtained to search that location?
Yes.
And approach defense counsel. I'm approaching with states 106 through 110. Do you recognize these photographs?
Yes.
And what do these photographs depict?
These are of the backyard. This photo states exhibit 106 is from the right side of the residence going into the backyard.
Okay,
The rest of them are in the backyard.
okay, and would it be fair to say that the photos kind of give a panoramic view of the backyard?
Yes,
And have they been altered in any way?
no,
Your Honor, state would offer state's exhibit number 106 through 110.
Board Director,
Yes.
Officer, did you take these pictures?
no, sir.
When was the first time you saw them?
Those pictures?
Yes.
Yesterday.
And this trip that you made out to the scene was 3.5 years ago.
Yes, sir.
The jury objected, he cannot lay the proper foundation for admissibility of these items.
All right. States exhibits 106 and 110 are admitted.
Permission to publish, Judge?
Granted.
Now, would you agree with me that there were a lot of items in that backyard?
Yes, sir.
And after the search warrant was obtained, did you start to investigate any of these items?
Yes,
What items were you looking at?
the vehicle parts.
And what type of vehicle parts were there?
We're gonna, we approach Judge.
Yes. All right, I do remember you asking her question and her stating that all the other items belong to them. I could be wrong. So Diana will be able to see if she can find it.
Yes, Judge, but if that, even if that's the case, that would be impeachment as to her. In other words, that would suggest to the jury that maybe she's lying. She's not on trial here. And we can't impute misstatements, lies, whatever else, extraneous offenses that she may be committing in his trial for something else.
Do y'all wanna look with Diana and see?
That, my notes say that the question from Ray was belief that the area behind your house was solely your property, and then she says yes.
I do
All right,
recall asking her, did he in the past buy and sell things? I didn't say stolen things.
Understanding was Jose had bought all the items, yes.
What date was she on here?
Jeez.
At this point.
What day is today? Wednesday.
This is she, just
Six.
six. All right, so here's the issue, Diana. It's his ex who testified. What we're trying to discover is whether or not Ray asked her, or if it happened under his cross-examination, that she said the items in the back belong to them. Am I correct?
Yes, ma'am, and it's, sorry, I didn't mean to cut you off. And it's part of this line of questioning where Ray's like, well, he works as a mechanic, he would buy tires, car parts and sell them, right? And you wouldn't sell them, right? Edith, it was Jose who would sell them. That's like what we're trying to get at.
All right, so if you can tell me where that is, and then I'll make a ruling on whether or not it's relevant or should be in at all. So if y'all would check with Diana, and let me take this off. Yes.
Oh, here's another one. Vehicles, furniture is not.
After the search warrant was obtained, were any items taken into custody as evidence as a part of this case?
Yes,
And were those items both inside and outside of the home?
yes, sir.
And were you there to help collect these items and load them back up?
Yes, sir.
Pass away.
All right, defense?
Sorry, is it officer or detective?
Detective.
Detective. So when you recover stolen property, what is the protocol or what is the manual say you're supposed to do in terms of documenting what you recovered?
Should be an inventory list, but San Antonio Police did the inventory.
Okay, well, just so the jury understand, I understand what you're saying, but just so they understand, tell them what an inventory list is.
Inventory list would be any item that is collected will be documented. A copy should be left with the residents. It'd be same on the search warrant. You just have a list of what was seized.
Okay. So let's cover both those one at a time. So you leave a list with the actual people at the home that you're searching, correct?
You should leave a copy there.
And would you agree with me that the purpose of leaving them the list, if there's ever a dispute, hey, you took something from my house that belongs to me, not to, that you think is stolen, you go back to the list.
Yes, sir.
Okay. But, and then going back to the search warrant, you're required under law to submit an inventory after a judge gives you a warrant allowing you to search a particular location.
Yes, sir.
In other words, just go through this process. When you want to search somewhere, you can't just go because you want to, right?
No, sir.
There has to be a legal basis to do it.
Yes, sir.
And would you agree with me, one of those legal bases is, which is probably the most safe one to use, is to get a judge to sign a warrant.
Yes, sir.
And when the warrant is signed, the judge tells you, I'm allowing you to search a house, a car, whatever it may be. Correct?
Yes, sir.
And then you go and do exactly what the judge said you could do.
Yes, sir.
In this particular case, you obtained a search warrant for this Green Lawn address. Is that right? Did I get the right street?
Greenwood.
Greenwood. Greenwood. And what did that allow you to search?
I don't know. I didn't do the warrant.
Okay.
I've never even seen the warrant.
Okay, so some examples could be the interior of the home.
Yes.
It could be garage.
It's usually the property, to include the house or surrounding outbuildings.
Okay. And the law requires you to actually go back to that judge and give him a list of things that you confiscated pursuant to that warrant.
Yes.
You're saying you didn't do that because it wasn't your warrant.
Yes, sir.
But if it was your warrant, you would have done that.
Yes, sir.
What if you encounter a scenario where you go search somewhere and you confiscate like dozens of items? Or is that an exception? Well, there's just too many to list.
No. I list them.
Okay. Is it sufficient to take photographs and say, well, I didn't make a list, Judge, but here's a bunch of pictures of what we took?
That I'm not sure of.
Have you ever done that?
No.
Okay. So, and I know it's probably obvious, but when you say list, you actually do 1, 2, 3, as many as there are, and describe each item that was confiscated.
Yes.
Okay. Would it surprise you that an inventory list was not submitted in this case?
I'm not aware of it. I don't know who was in charge of the inventory. I mean, we were out there for 8 hours, so
And how many officers were out there?
I couldn't tell you.
More than a couple.
Oh, yeah, there was a few.
So certainly you had the manpower to make the list.
Like I said, I wasn't in charge of that part.
When you make your list, you handwrite it or you put it on a computer? How do you do that?
Handwriting.
Would you ever execute a search warrant and not file a return with a list of inventory list?
Has it happened before? Yes.
Would you ever do that?
I have forgot to do a list.
Well, and now you anticipate my next question. The only reason was because you forgot.
Yes.
You didn't intentionally do that.
Not intentional.
Have you ever had occasions where somebody in the magistrate's office that handles the search warrant issuance calls you and says, hey, we haven't gotten your inventory?
No.
Okay. Have you had attorneys, prosecutors, other people come back and say, we can't find your inventory?
Not.
Because you always submit one, right?
Yes.
I want to turn your attention, Detective, to the pictures. It seems like the point of view is looking down the driveway on those pictures, right?
There was really no distinct driveway. I mean, it's just open on both sides.
Okay,
Now, could
Well-
they been used as a driveway? Yes.
well, do any of the pictures depict the front door?
Not the ones that I was shown.
Okay. So when you do a knock and talk, are you allowed to go throughout the entirety of the property?
The 2 deputies were sent to the back for officer safety reasons. I stood on the right-hand side of the porch, looking down
There's
the
no
back.
object is not responsive.
All right, that'll be sustained.
So the question, officer, and I don't want to quarrel with you, I just want to make sure we go through this logically. When you go to a knock and talk, are you allowed to wander around the premises of the place you're going to go knock on?
No,
Okay. And so the jury understands what knock and talk means. You're going at that point without a warrant, correct?
going where?
Wherever you're going to do the knock and talk.
Oh, yes. Walk up to the front door, yes.
Because when you have a warrant, that's permission to do whatever you want to do within the confines of the warrant. You don't need to ask anybody at the front door for permission, right?
Yes, sir.
But when you don't have a warrant, that's when you go knock and see what you can get voluntarily, maybe.
Possibly.
In some cases, they might say, sure, search all you want, right?
It has happened.
And in some cases, you might get information that helps you document the reasons for the warrant.
Yeah, to develop probable cause.
Exactly. And in fact, that's what you're doing in this situation, correct?
I was not doing it. It was, I was there. I didn't knock on the front door.
Okay. But you agree with me that when it's a knock and talk and not an execution of a warrant, that you're more limited in what you're legally allowed to do.
Yes, sir.
For example, you couldn't just go in the home uninvited,
Oh, no, sir.
and you couldn't go to the backyard uninvited.
No, sir. Unless you have probable cause.
Okay. Now you suggested despite what you just explained to us, that you instructed patrol officers to go behind the house. Or somebody did.
To watch the house, watch the back of the house.
Is that where they were able to see in plain view things that were in the backyard?
I could see in plain view from the side of the front of the house.
You could see in plain view items in the yard, correct?
Yes.
You couldn't look into the car from the front of the house.
What car are you talking
It
about?
was a red truck in one of those pictures, isn't it?
Oh, yeah, I wasn't looking at that.
Okay.
There were other vehicle parts
Okay.
there.
And it's not illegal to have vehicle parts in your yard, is it?
No, sir.
So who did sign the affidavit for the search warrant in this case?
I had no idea.
Well, let's find it. May I approach, Judge?
Yes.
Does that look like a standard application for a search warrant?
Yes, sir.
If you could read to yourself the details of the location and the date, and then I'll ask you some more questions. Does that appear to be the search warrant attached to the investigation you participated in December of 2020 in Adams?
Yes, sir.
Okay. Do you now know who did the affidavit for the search warrant?
Yes, sir.
Was that a member of San Antonio law enforcement?
Yes, sir.
Was that person with you when you went to do the knock and talk?
No, sir.
Was there a separate knock and talk or was it just the one that you did?
Just the one we were there.
So you're saying that the person who signed the affidavit saying that he saw things in plain view wasn't even there at the knock and talk?
How it's written, yes.
Okay. So have you ever written an affidavit for a search warrant?
Yes.
And the information that you attest to in your affidavit, where do you get it from?
It depends. If I have it, if another officer gives it to me, I usually put their name in there.
Okay. But in some cases, it's things that you personally observed, correct?
Yes,
Whether it was in a knock and talk or as part of an investigation you're conducting, correct?
yes,
Because the affidavit for the search warrant is the officer basically telling the judge, Judge, this is what I know, and I'm gonna swear to it. And then you give me the warrant,
yes, sir.
correct?
Yes, sir.
And so do you, I won't ask about other officers, but do you personally take that very seriously, that if you're swearing to something, you need to know that?
Yes, sir.
You're not gonna put, I think they might have stolen stuff. You gotta tell them what you know and how you know it, right?
Yes, sir.
Okay. And so you just now told us that if another officer gave you information, you'd want the judge to know, this particular information came from officer so-and-so, and I'm relating it to you, versus things that I know that I'm telling.
Yes, sir.
Because it's a big deal if a judge finds out later that there was false or misleading information in an affidavit.
It could be.
Because the judge is relying on the officer's word in giving that permission to go into somebody's property.
Yes, sir.
Okay. So who was the person who signed the affidavit for the search warrant in this case?
Detective Moscoso.
And your testimony officers, when you went to do the knock and talk, he wasn't there.
No,
When you went and made contact at that location, was that the first time law enforcement had been at that location as a result of this particular case?
as far as I'm aware, yes.
Because as you stated to us earlier, you officers work in close concert with each other, correct?
Yes, sir.
So if someone else had some prior knowledge or involvement with that address, you would have known that before you went out
Yes, sir.
there. And that wasn't the case in this situation.
I don't recall if I looked up the address for any priors. I believe I did.
So who was in charge of this knock and talk?
Detective Hodge.
But he's not the applicant on the search warrant either.
No, sir.
And so describe this for us, since we weren't there. Who's knocking on the door and where's everybody situated?
Detective Hodge went to the front door. I went to the right side of the residence to make sure no one comes out the side. And I had the two deputies go towards the back so they can watch the back.
Okay. Now, to be clear, officer, there's no allegations that there's any violent people in this house, correct?
No, I do that on everyone.
And there was no information that any crime was actually being committed at the time that you were there.
No, sir.
So it was just being extremely cautious
Yes, sir.
because you don't know who's there and what you might find.
Exactly.
Okay. So part of the basis that allowed the judge to issue the warrant, now that you've looked at it, was things that were seen on the property. Correct?
Yes, sir.
Were they things that you saw or somebody else, if you know?
I saw him.
Well, you saw car parts generically, correct?
I saw that and I saw the camper show.
Okay. And you saw that while you're standing in the front yard?
Not the camper show, but the car parts and all the other items that were in those pictures.
Which is a bunch of boxes.
Boxes, yes.
So certainly from where you're standing, you can't tell if that's stolen property
No.
or whether those boxes are empty.
At that point in time, I didn't know what was stolen.
And didn't know what you were looking at other than, and you couldn't see the camper shell, right?
Not the original. When I walked around, I could see it.
When you went to the backyard.
Yes.
So, and you may or may not know the answers, but if you know the answer, when you read that affidavit and it's stated in there that things were seen in plain view, who's saying that?
According to the affidavit, Detective Moscoso.
Who wasn't there?
Not at the knock and talk.
And how is it that you come to that conclusion that he's the one that saw it in plain view? Is it because of the way he wrote it?
Okay, actually on the warrant, it does say other detectives from the San Antonio Police Department.
Well, I'm focused on the affidavit, officer, not the warrant itself.
What was your question again?
Specifically in the affidavit, there's a reference to seeing things in plain view. Would you agree?
Yes, sir.
Based on your reading and your knowledge of how affidavits are written, who do you believe is talking when they say, I see in plain view?
Object to mischaracterization, where in the document does it say I see?
Well,
Say that.
it says,
All right, counsel, re-ask your question, please.
there's a reference to plain view in the affidavit for the search warrant, correct?
Where is that listed in?
May I approach the witness, Judge?
Yes.
I want to make sure we're both looking at the same thing.
And Your Honor, may I approach as well, just to make
Yes.
sure we're all on the same page?
I'm not seeing.
David's here.
Yes, they're just reviewing things.
That's.
All right, counsel, what's your question?
So in looking at the affidavit, officer, can you determine who is the person that suggested items were seen in plain view?
Says deputies.
So that refers to the two officers that went to cover the back door.
Yes,
Okay. You're not one of the persons that suggested you saw what you believe to be contraband in plain view,
no,
because you.
I don't know how he referenced it,
Okay,
who he's saying. I mean, there were 3 deputies out there, 2
okay.
deputies and myself.
So there's the two that went to the back door, right?
Well, they didn't go to the back door, they just went to the back side.
Okay, back of the house,
Yeah.
somewhere. And then you're on to the right of the front door,
Yes,
and then there's one officer, Hodge, at the door.
yes, knocking,
So there's 4 in total.
yes,
And so the way you read this affidavit is that the persons who saw items in plain view were the officers that were to the rear of the property,
yes,
and not the person who wrote the affidavit.
correct.
That's what it's judge.
State,
State.
all right, is this witness excused or subject for recall?
Use.
All right, the rule has been invoked. What that means is you cannot discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state or the defense. All right, you may step down. Thank you. State, call your next witness.
Your Honor, the state calls CSI Scott Coonrat.
Could you state your name for the record?
Scott Coonrad, Coonradt.
Right, state.
All right, so CSI, Coonrat, who do you work for?
I work for the San Antonio Police Department,
And how long have you worked for the San Antonio Police Department?
just under 26 years.
And what do you do for the San Antonio Police Department?
I'm a crime scene investigator.
And is the abbreviation for that just CSI?
Yes.
Is that usually how people would imagine it from TV shows or movies?
No.
Would you agree that it's quite different?
Yes.
What are your duties as a CSI?
Basically, depending on the call or the case, we go out, we do everything from photographs to fingerprints to other types of documenting the scene, collecting evidence.
So do you go on your own or are you usually asked to come out somewhere?
We're usually dispatched or called.
And I want to draw your attention to December 22nd of 2020. Were you working on that day?
Yes.
And were you called out to help process a scene?
Yes.
Do you recall what was the address that you were called out to?
Could I see my report?
Copy of your report. If you just do me a favor, just can't read directly off of it or from it, but you can refresh your recollection and then answer the question.
Yes, I was dispatched out to 13641 Greenwood Road.
And what did you do when you were dispatched out to that scene?
I made the scene and contacted detectives out there who were executing a search warrant.
And as a part of processing the scene, what primarily were you doing?
On this particular case, I was just requested to take photographs of the overall scene to include some recovered stolen property.
And walk the jury through what goes into you taking photographs of the scene. How do you approach it?
Basically, when I get there, I kind of like start from the outside and photograph the overall scene, try to get like an address, and then work my way in, photograph, kind of the overall exterior. If I'm going into a house, photograph the location, if there's an address on there or say an apartment number or room number, building number, and then go inside, do overall photographs in there. And then depending on the type of case and the detectives out there, sometimes, they want specific things photographed like they did in this case.
So do you take direction somewhat from the detectives or people handling the scene as to what to document?
On this particular case, yes, because there were actual follow-up detectives out there.
So I'm gonna approach. Approaching with what's been marked as station exhibit number 111. Do you recognize this? And the item that was in states 111, it's an envelope.
Yes, it's a disc that has my name, photos, and then I initialed it, put my badge number and the date that I looked at the photographs.
And on this disc, are these the photographs that you took back in December of 2020?
Yes.
Okay, and are the photographs that are on this disc, have they been altered in any way?
No.
Honor, the state would offer states exhibit number 111 and this side.
Any objection?
Just a couple of questions. How many pictures are we talking?
It's like 290.
Just briefly, Judge, and I can, more dire, just so I can make
Yes.
sure I can object or not. So can you just tell us did you just took pictures of basically everything that was on the property as you saw it?
Basically, yes. And like I said, I started on the outside. They had me photograph. There was a bunch of stuff in the rear of the location outside. And then they had me photograph the overall inside to include some specific items that they were wanting documented.
And who is directing you to take these pictures?
Various detectives with our auto theft unit.
So it's things that are in the yard and things that are in the house, they ask you to take pictures of.
Yes.
Okay, no objection, Judge.
All right, States Exhibit 111 is admitted.
Now, I'm gonna show you what was previously marked States exhibits numbers 3 and 83. Now, I'd like you to take a brief moment just to kind of take a look through some of these photographs and see if you recognize any of them.
Yes, those are all pictures of various items and stuff that I was requested to photo.
And you took photographs of those items at the address on Greenwood, is that correct?
Yes.
Pass the witness.
No questions.
All right, is this witness excused?
Yes, Your Honor.
All right, the rule has been invoked. What that means is you cannot discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state of the defense. You may step down. State, call your next witness.
State rest, Your Honor.
Defense.
Judge, we have a motion we'd like to present to the court.
All right. Can I have both parties approach, please? All right, ladies and gentlemen, I'm going to let you all enjoy your lunch break at this time. And I'm going to have you all come back at 1. I think that'll give you plenty of time to walk around downtown and find a place that maybe is not as expensive. If you go off the beaten path, it's less expensive and you can grab a sandwich or something and just enjoy the river walk. I think there was some rain or something last night, so all of the pollen and whatever's out may have been washed away. So we'll come back at 1. Remember my instructions. You're not allowed to talk about this case to anyone. You're not allowed to start internally, thinking about the case with yourself or discussing it with each other. If you see anything or hear anything, you're to ignore it. Make sure your badges are visible because sometimes attorneys will talk about cases, but if they see that the jurors around, they will not. Remember, everything that you need to know about this case is to come from. All right. All right, everyone, please rise for the jurors. You have rested and defense, you have a motion.
Yes, Judge, we'd like to move for an extracted verdict on the indictment as it's set out before the court.
All right. And
Well, Judge, the evidence that's uncontroverted from the complainant himself was that the value in total was way less than $300,000. Even though he moaned and groaned and complained about what he settled for, bottom line is he acknowledged that he signed a document where he agreed in the settlement of his case that the value and the worth of the items that were stolen from him we're way under 300,000. I think the exhibit that's been admitted into evidence suggests 214,000.
Okay. All right.
And I'm sorry, Judge, and there was one other point. He also said there was nothing of any value that was in the items that were returned to him, which the only evidence of items that my client was ever in possession of was what was taken from his property.
All right, and state.
Your Honor, we oppose the motion. All we need is a scintilla of evidence to get past this motion, Judge. And so the evidence, I think, there's enough evidence in front of the jury that they could find defendant guilty based on the facts and evidence. They can make reasonable inferences from the evidence that's been presented. Also, in this document, the RCB value is over $400,000, which is what USA values the property at. So I mean, the settlement value may be less, but the value that USA said, hey, this is what these things are worth, that's higher than the minimum amount we need to reach, Your Honor. So for those reasons, we ask that you deny the defense's motion.
I couldn't disagree more, Judge. That's not what that document says. It says, if you read it completely all the way to its end, it gives you the actual cash value. And for purposes of theft, it's the value of the item at the time that it's stolen, not what you might have paid for it before. So they negotiated to the actual value, and that's what he settled for, and that's what he accepted.
All right. So which exhibit number is this, please?
It's defendant's 2, Judge.
Yes, ma'am.
All right, so this is what we're gonna do. We're gonna go ahead and take our break so Diana can have a break. I'm gonna review defense exhibit number 2. And I'm gonna have you all back here at 12:30. I have emailed you all the jury charge. Well, you know what? Let's say 12:45. Because I've emailed both parties the jury charge and I will come back with my ruling. But please review the jury charge and let the court know if there's anything you want added or subtracted. What I can tell you is what's in the jury charge are lessers if anyone wishes to have lessers. And also the issue with regards to the search warrant is in the charge as well.
So, Judge, we haven't gotten on the record yet. Who's asking for lessers?
No, I'm just saying, what I do with the jury charge is I put everything in the jury charge. You all can review it and then you can make a decision on what you don't want in it or what you do want in it. If you don't come up with an agreement, then I'll make a ruling on that. So far, nobody has asked for anything. So far, you haven't asked for anything as it relates to the search warrant. The state hasn't asked for lesser included, but I've just given that to you all so you all can review it during the break. And then when we come back from the break, I will give you my answer with regards to your motion. And also, if I rule against your motion, then you all will help already review the jury charge. That's the court's only point, because I don't want the jury to be waiting.
Okay.
The only other thing, Judge, I guess on this particular matter is we have the defense exhibit 2 has one set of numbers, and then state's exhibit 84 also has a different set of numbers. So I think that's a question of fact that the jury needs to consider, Judge.
All right, so for me to make my ruling, if I could please see the defense exhibit that you're speaking of with the value and also the state's exhibit. And with that being said, we're going to take our recess. We're going to come back at 12:45. At that time, if there's some issues with the jury charge, everyone needs to let me know what those issues are. And at 12:45, I will come back with my ruling on this.
Yes, ma'am.
And Judge, since you're gonna be looking at those things, let me just make sure that the record's clear. I'd ask the court also to revisit your ruling on the motion to suppress in light of Officer Knocker's testimony. He clearly stated that plain view only occurs when somebody goes into the backyard. He also suggested that the person who requested the search warrant is not the affiant. And finally, he also suggested that the law requires and policy requires an inventory to be returned, which was not done in this case at all.
All right, so with regards to law, the court knows the law. But with regards to your stating that the affiant who obtained the warrant, are you saying that the affiant was untruthful in the request for the search warrant?
Well, I think he was misleading and ambiguous about certain issues. For example, the plain view, he doesn't say how they plain view from where, like how, so I could see where the court could interpret, they saw that in a way that was not violative of the Fourth Amendment.
But are you saying that the affiant was untruthful? That's what I need to know. Because if you,
If I had to pick, I would say yes, because he's misleading and untruthful are just two ways to say the same thing. He didn't give the court truthful information that the persons who saw things in plain view were officers who were placed where they weren't supposed to be. And Officer Knocker, who was there, saw them doing that. As a matter of fact, he suggested, he told them to go back there where they weren't supposed to be, and then use the information that they obtained. So yes, I would say that's exactly what he told us, that, and he demonstrated his very clear understanding of how search warrants are done, how they're obtained, what's required to be in the affidavit. He's very knowledgeable because he's done this many times. And I think he even acknowledged himself,
okay,
maybe we kind of bent some rules there.
all right.
Judge, I don't think that's supported by the record with Edith Solano's testimony. She says that backyard is a shared space between at least 3 houses. There's no fencing back there that sections off the defendant and Edith's backyard. And then with the detective's testimony, he says he went back there. You could see from where he was on the side of the house in plain view, these items strewn about. And so, Judge, I think your earlier ruling on this matter is what you control here, where you excise portions of the warrant or the affidavit for the warrant and still found sufficient probable cause, and that's what I think we should go with, Judge.
All right, so with regards to revisiting the motion to suppress as it relates to the search warrant, the court has heard the arguments from both parties. The court's previous ruling will stand. I did have a chance to review Defendant's Exhibit number 2 and State's Exhibit number 84. Both of those were admitted into evidence. What is in Defense Exhibit number 2 is a document that has USAA at the top of it. And it has a claim, a net claim remaining of $137,397.29. State's Exhibit number 84 has in it a total value of $366,605. So with regards to your request for a directed verdict, that will be denied. All right, so we will come back at 12:45. If you all will look over the jury charge and let me know if you're in agreement with it, or if there's something else you want added or taken away, let the court know. And of course, that is not the final charge. That is just the court putting everything in the charge that potentially may be asked for by both parties. I have not made up my mind or intend to make a ruling that that is the final charge. That's just in anticipating what I thought maybe both parties would be asking for. If it's something you do not wish to be in the charge, just let the court know. Does everyone understand?
Yes, ma'am.
All right. All right, thank you. We're going to go on recess. And with that, State, do you rest?
Yes, ma'am, we rest.
All right, defense. State, do you close?
Yes, ma'am, we close.
Defense?
Yes,
Okay. All right. Ladies and gentlemen, what's going to happen now? Both sides have rested and closed. I'm going to read to you the jury charge, or what's called the charge of the court. You do not have to memorize that. You will be given my copy to take back with you to the jury room. Charge of the court. Members of the jury, the defendant, Jose Lozano, stands charged by indictment with the offense of theft, $300,000 or more, alleged to have been committed on or about the 4th day of December 2020 in Bexar County, Texas. The defendant has pleaded not guilty. 1, our law provides that a person commits the offense of theft if he unlawfully appropriates property with intent to deprive the owner of property. Appropriation of property is unlawful if it is without the owner's effective consent. 2, appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Property means tangible or intangible personal property or documents, including money that represents or embodies anything of value. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. Value is 1, the fair market value of the property at the time and place of the offense, or 2, if the fair market value of the property can not be ascertained, the cost of replacing the property within a reasonable time after the theft. 3, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. 4, now if you find from the evidence beyond a reasonable doubt that on or about the 4th day of December 2020 in Bexar County, Texas, the defendant, Jose Lozano, with intent to deprive the owner, Terry Kirkbride, of property, namely clothing, electronic items, household items, tools, toys, sporting goods, weapons, fashion accessories, jewelry, magazines, books, paintings, artwork, collectibles, vintage movie items, antiques, motor vehicle parts, military collectibles, United States currency, and or food items did then and there unlawfully without the effective consent of the owner, Terry Kirkbride, appropriate said property by acquiring or otherwise exercising control over said property being other than real property which had a value of $300,000 or more, then you will find the defendant guilty of the offense of theft, $300,000 or more, as charged in the indictment, and do not consider any lesser included offenses of theft as instructed in paragraphs 5 through 7, but instead proceed to paragraph 8. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of theft, $300,000 or more, as charged in the indictment, say by your verdict not guilty of the charged offense of theft, $300,000 or more, and proceed to paragraph 5 to consider whether the defendant is guilty of the lesser included offense of theft, $150,000 or more, but less than $300,000. 5, now, if you find from the evidence beyond a reasonable doubt that on or about the 4th day of December 2020 in Bexar County, Texas, the defendant, Jose Lozano, with intent to deprive the owner, Terry Kirkbride, of property, namely clothing, electronic items, household items, tools, toys, sporting goods, weapons, fashion accessories, jewelry, magazines, books, paintings, artwork, collectibles, vintage movie items, antiques, motor vehicle parts, military collectibles, United States currency, and or food items did then and there unlawfully without the effective consent of the owner, Terry Kirkbride, appropriate said property by acquiring or otherwise exercising control over said property being other than real property which had a value of $150,000 or more, but less than $300,000, then you will find the defendant guilty of the less included offense of theft, $150,000 or more, but less than $300,000, and do not consider any lesser included offenses of theft as instructed in paragraphs 6 and 7, but instead proceed to paragraph 8. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of the lesser included offense of theft, $150,000 or more, but less than $300,000, say by your verdict not guilty of the lesser included offense of theft, $150,000 or more, but less than $300,000, and proceed to paragraph 6 to consider whether the defendant is guilty of the lesser included offense of theft, $30,000 or more, but less than $150,000. 6. Now, if you find from the evidence beyond a reasonable doubt that on or about the 4th day of December 2020 in Bexar County, Texas, the defendant, Jose Lozano, with intent to deprive the owner, Terry Kirkbride, of property, namely clothing, electronic items, household items, tools, toys, sporting goods, weapons, fashion accessories, jewelry, magazines, books, paintings, artwork, collectibles, vintage movie items, antiques, motor vehicle parts, military collectibles, United States currency, and or food items did then and there unlawfully without the effective consent of the owner, Terry Kirkbride, appropriate said property by acquiring or otherwise exercising control over said property being other than real property, which had a value of $30,000 or more, but less than $150,000, then you will find the defendant guilty of the lesser included offense of theft, $30,000 or more, but less than $150,000, and do not consider the lesser included offense of theft as instructed in paragraph 7, but instead proceed to paragraph 8. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of the lesser included offense of $30,000 or more, but less than $150,000, say by your verdict not guilty of the lesser included offense of theft, $30,000 or more, but less than $150,000, and proceed to paragraph 7 to consider whether the defendant is guilty of the lesser included offense of theft, $2,500 or more, but less than $30,000. 7. Now, if you find from the evidence beyond a reasonable doubt that on or about the 4th day of December 2020 in Bexar County, Texas, the defendant, Jose Lozano, with intent to deprive the owner, Terry Kirkbride, of property, namely clothing, electronic items, household items, tools, toys, sporting goods, weapons, fashion accessories, jewelry, magazines, books, paintings, artwork, collectibles, vintage movie items, antiques, motor vehicle parts, military collectibles, United States currency, and or food items did then and there unlawfully without the effective consent of the owner, Terry Kirkbride, appropriate said property by acquiring or otherwise exercising control over said property being other than real property, which had a value of $2,500 or more, but less than $30,000, then you will find the defendant guilty of the lesser included offense of theft, $2,500 or more, but less than $30,000. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of the lesser included offense of theft, $2,500 or more, but less than $30,000, and say by your verdict not guilty of the lesser included offense of theft, $2,500 or more, but less than $30,000. 8. You are instructed that under our law, no evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or the Constitution or laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. An officer's observation of an item in plain view is not an invasion of a person's right of privacy if the officer observing the item is properly in a position from which he can view the property. Also, it must be immediately apparent to the officer viewing property in plain view that the items observed in plain view might be contraband or evidence of a crime. That is, there must be probable cause to associate the item or items in plain view with criminal activity. Probable cause exists where the facts and circumstances within the officer's knowledge and of which he has reasonably trustworthy information are sufficient unto themselves to warrant a man of reasonable caution to believe that an offense has been or is being committed. If you believe or have a reasonable doubt that evidence was obtained in violation of any provisions of the Constitution or the laws of the state of Texas or of the Constitution or laws of the United States of America in such event, the jury shall disregard any such evidence so obtained. 9, our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it in consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service or any text or instant messaging service or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements or reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charge beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by your presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. Are parties ready to proceed with closing arguments?
Yes, Your Honor.
All right, State, you may begin.
Now, the first thing I want to mention is that, don't worry, you didn't have to memorize all that the judge just said. You're going to have the jury charge back there with you. And now, part of it is that there are multiple, well, let me just tell you the elements. In Bexar County, Texas. So again, we've proven that this all occurred in Bexar County. On or about December 4th, 2020. Again, multiple people testified that that's when the property was stolen and when the trailer was found. Jose Lozano. Again, Edith came in and identified Jose. He was also identified by the fingerprints found on that trailer by the fingerprint analyst who came in and testified. With intent to deprive Terry Kirkbride, the owner of property, unlawfully, without effective consent, appropriated property. Then it lists the different categories of property that were appropriated. And again, those 3 points I just mentioned, that's the crux of this case. Now, one thing that you should have noticed during the reading of the jury charge is valued at $300,000 or more. So there are multiple different parts to theft that you have to decide. So the first thing that you can decide is if we've met our burden of above $300,000 or more. Well, then it stops there. That would be what he's guilty of. If you don't find it above 300,000, then you would go 150,000 or more, but less than 300,000. The further step is, again, valued at 30,000, but less than 150,000. And finally, valued at 2,500 or more, but less than 30,000. So again, you only go to the next step. You only go to the next value amount if you find that the first value amount is not true. Then you go to the next one, If that's not true, you go to the next one until you make a decision. Now, you heard plenty of testimony in this case from officers who were investigating what happened. You heard from Terry, who I know it took a while to go through those photos, but he detailed exactly what property was found at Jose's home and what he was able to identify. Again, that's not all the property that Terry had. It's just what they took photos of. You also heard from Edith, that's the mother of Jose's children, who did state that he lived at that address, that he had brought this property to that home, and that he didn't say where he got it from, who he got it from, when he got it, only that she remembers it was not that long before the police arrived. So again, you've heard plenty of testimony as to the circumstances around what happened to Terry Kirkbride's property. What I want to mention is that there have been plenty of police reports that have been mentioned during the course of this trial. Several times officers, because this happened 4 years ago, they didn't have a great memory of exactly what happened, but that's why they write police reports. But unfortunately, as it says in the jury charge, you're not going to get any of those. It's again, for purposes of refreshing their memory. What I want to say also is that you cannot let bias or sympathy play a role in your decision. You have to look at the evidence that's presented. Now, again, in each of these different lists of the elements, all the elements are the same except for the value amount. That's really where that decision has to come in. And it's whether or not the state, beyond a reasonable doubt, with all the evidence that was brought in, with the testimony that you heard, did we prove each and every one of those elements? I would argue that we did. And I would ask that you find the defendant guilty of theft $300,000 or more. And I'll reserve all remaining time for final closing.
All right. Defense, are you ready to proceed?
Yes, sir. Please, court, counsel. Good afternoon again, everybody. So I want to start off with a couple of housekeeping things. First of all, if you have a dispute about what some of the testimony might have been, do not send a note to the judge asking, can you read us back the testimony of Officer Felony? Because you're not going to get it, right? The law says you can get information like that, but it has to happen this way. Y'all are deliberating, you get to a specific point that you're conversing about, and juror number 1 says, that officer said this. Juror number 3 says, no, they said this, in response to a specific issue or question. And even a third juror says, no, I think they said that. If you give a judge a very specific question about what you're disputing, then you'll get an answer, probably. But if you say, we want to hear all the testimony of Officer Knocker, that's not going to happen. So don't ask for that. I want to talk a little bit about unanimous verdicts. What seems like a relatively simple case has raised a lot of interesting questions. And you may not agree on all of them. You may not agree on any of them. My request to you is to live up to your oath and decide the case as you see it. And if you get to the point where your decision is at odds with others and you don't come to a unanimous verdict, whether it's 11-1 or 6-6 or 8-4, it doesn't matter. At some point, you are allowed to notify the court and say, Judge, we're deadlocked. And then the judge will give you further instructions. But don't sit back there just like, well, what do we do? Deliberate, try to come to a conclusion. If you cannot, you cannot. First thing I want to talk about is, this is why jury duty is very, very difficult and sometimes. Yes, it's true. All we have is a property case here. Nobody got hurt, thank God. It's not a violent offense. But it was heartbreaking to hear Mr. Kirkbride talk about the things that he'd accumulated over his lengthy career, a very honorable career that he had, and lose them. When him and his wife were so looking forward to moving to California to be near their kids, they pared all their things down to just what they needed to take, and then this happens. I'm sure everybody here was heartbroken to hear that story. It was hard to hear him testify about that. I felt the same way. But that's not what you're here to talk about, and that's what you're not going to deliberate about. What you're going to deliberate about is the legal questions that are presented to you. That's whether or not this particular crime was committed. And the first thing that is difficult to talk about is this may have all been done illegally. There's a provision in the law that says basically, if the police officers violate Fourth Amendment, unlawful searches and seizures, the jury disregards the evidence. And the case basically goes away. In other words, what was confiscated in that yard that day, if it was confiscated illegally, the jury is not allowed to consider that evidence. Without those items in the yard, there is no case, right? We know that, right? So how did they violate the law? Officer Knocker told you very clearly, very plainly, that you can't just go to somebody's house and go in their backyard. I guarantee you, every single one of you would take offense to a police officer deciding, I'm going to wander into your backyard, I'm going to look into your cars, I'm going to look through the windows, and I'm going to see what I'm going to see. And maybe I'm going to come back with a warrant and search. And it's absolutely, clearly, undeniably against the law. That's exactly what they did in this case. Not because I say that, not because my witnesses say that. Officer Knocker told you that, right? You don't have to have a fence for it to be your backyard, right? The fact that you live on property that a fence has fallen down or you can see around it, that doesn't mean you just can mosey on back there. Officer Knocker told you, yeah, I send the guys back there just on the safe side. But there was nothing happening that required that to take place. They weren't searching for somebody with a warrant. There was no crime being committed. They just did it. And then he tells you the plain view that's listed in the affidavit for the search warrant is because those officers were back there looking around. Your deliberations, if you were to follow the law and be true to the oath that you took when you started this case, would be, that's the end of our conversation. That testimony is absolutely 100% undisputed. Nobody challenged that. Everyone has a right for their backyard, their property, to be free from unreasonable searches and seizures. It's part of the law. It's part of the Constitution. And the consequence for violating that is anything illegally obtained is not admissible in court. I know that leaves a distaste in everybody's mouth if that's the conclusion you should come to, because you would want the police to do it the right way. You would want them to legally obtain the evidence so that you could do the right thing by Mr. Kirkbride. I get all that. Difficulty of jury service is you have to follow the law because you swore to this, what you're going to do. So I'd ask you to delve very deeply into that question and come to the conclusion that this was illegally obtained evidence. Paragraph 8 tells you very clearly, it's page 8, paragraph 2. Plain view is not an invasion of a person's right to privacy if the officer observing the item is properly in the position where he can view the property. Meaning, if he's legally there, whatever he sees is admissible. You know the answer to that question. That's undisputed. If you feel you have to go beyond that point, I understand. Let's talk about it. Why do we have all these different ranges of values when the indictment very clearly states, and it was read and Mr. Lozano pled not guilty to, over 300,000. It doesn't give you 150 to 300. It doesn't give you 30 to 150 or 2,500 to 30,000. Why do we now have those options when he was never charged with that? Because they didn't prove their case. It's a concession. It's a concession on the state's part that we didn't really get there. Let's give them some other options. That is so unfair. It's beyond description, because he's come here and he's been under indictment for a case over 300,000 that never should have been filed in the first place. And these different options they're giving you clearly indicates that that's the case, right? And how do we know that? Or how did we get there? Officer Knocker told you very clearly, when you go in and seize property, you'd have to do an inventory. All they had to do was give us an inventory of everything they found on the property. And I guarantee Mr. Kirkbride would have put a price on it because he knows his stuff. He knows what it is. He knows what it's worth. And the magistrate, by law, requires officers, when they execute search warrants, bring us that inventory and file it with the court. Didn't do that either. Officer Knocker said, I wouldn't have done it that way. I mean, I've done these before. This is how you do it, right? And guess what? It's one of the reasons is so they don't take property that doesn't belong, that maybe belongs to the homeowner, and it wasn't even stolen. That's exactly what happened here. Mr. Kirkbride told you, I found this winch thing that didn't belong to me in the property. So we don't know the value, and it's because the officers didn't do the inventory. And I think I know why, and I think you know why. There's a lot of stuff. Although it's mostly, as Mr. Kirkbride said, junk and trash, empty boxes and stuff. It was, they weren't gonna go through it all. So what did? They took 84 pictures or however many it was. That's not how you do it. Because then now they're leaving it up to you. Okay, here's all the pictures. Here's all these numbers. Figure it out. That's not fair. Do it the right way. Do what the law requires. Leave the inventory and file it with the magistrate the way you're required to do. Now, this case started off with the stealing of the truck and the trailer. What does this indictment say? And Mr. Kirkbride and I talked about that. They never accused him of stealing the truck. It's not in the indictment. They never accused him of being in possession or stealing the trailer. It's not in the indictment. And we know that it takes much less evidence to get an indictment than it does to get a conviction. There just has to be some evidence. They knew they had none, right? And you know they had none. Nobody sees him at the scene. Nobody sees him in the truck. The truck and the trailer are never on his property. There's no evidence of it. Yes, could you assume and speculate that somehow he was involved? Of course you can. But how does that get you beyond a reasonable doubt? It doesn't get you there. It's not any evidence. It's no evidence whatsoever. So the over 300,000 gets much harder to get to when the truck and the trailer are not even involved. This is about personal property that's on Mr. Lozama's property that is a small piece of a much bigger theft. How do they get beyond a reasonable doubt? They can't. There's no evidence whatsoever. None whatsoever how that property got there. There's no evidence of what all is included in that property, and there's no evidence of the value of it, right? That's how we get all the way down to $2,500, up to $30,000. And the last one they didn't tell you, if it's under 2,500, it's not guilty, because that you don't get 0 to 2,500. Why? That's not one of the options. But the reason I think you have to consider that is Mr. Kirkbride said more than once, they left nothing but trash. There was nothing of value, right? There was nothing of value. His words, his stuff, he knows. Don't believe us, believe the state's witness. The big concern is that a jury in this situation starts seeing things or putting pieces together that are not there, right? Well, maybe he did this. Well, maybe he did that. Let's talk about some of the maybes. What do thieves do when they steal stuff? What do they want it for? Oftentimes, many times, is to convert it to cash, right? Because the things that they stole in, they don't necessarily have a use for it. Yeah, sometimes they'll steal a car, but even then, they'll want to get rid of it because they don't want to get caught with it. So where does the stolen property end up? All over the place, right? All over the place. Some was left in the trailer. Some got to be, clearly it got picked through. We know that. Because what did Mr. Kirkbride say? Nothing of value was left. All the big items with the high value, the item that he said was worth $30,000 to $50,000, doesn't appear anywhere. You never see it. He never recovered it, right? And how do we know for sure all that's the case? Defendant's exhibit number 2 on page 6, and for several pages there following, he makes an exhaustive list, 300 line items of things that he made a claim to his insurance company, right? Telling them, I had these things, I don't have them anymore. I'm making a claim on my policy. The vast majority of what was in that trailer is in that list. And what does he tell you? Of those 306 line items, some of those have 10 and 15 items in one line. So it's a massive amount of property, right? And what's also important to get from this list, at the end of the day, and I know Mr. Kirkbride, and I'm sure the state will take the same position, you know, insurance companies are not nice people. They're not nice to deal with. They're not fair with you, right? But they paid him $214,000, right? And I'm not sure that includes the truck or not. But let's just assume it didn't. We all know 214 is less than 300. They were never going to be able to prove their case from day one. That's why they're trying to inch it down and let you prove it. But let's talk a little bit about the 214. Common sense suggests when you're having a negotiation and trying to settle your case with the insurance company, either you agree to the amount or you don't get your check. Right? Either you agree or you don't agree. He had a right to continue to pursue it. He could have sued him. He said, no, I'm done. I'm going to take that number. He agreed to it grudgingly. He didn't like it. He didn't want to do it. But you all know, common sense tells you, when you sign a release, you're telling them, I'm Mr. Insurance Company, I'm releasing my claim against you in exchange for the value that we've agreed my stuff was worth, right? And everything on this list that accounts up to $214,000 was not in my client's yard. These are all the things that were not found, right? Nothing that's on this list was in his possession. And this is the vast majority. I asked him that question, right? How much was left behind in comparison to what you made in your claim? Well, this is most of it, right? He made the bad decision. He was made the dumb decision to allow somebody to pawn some stuff off on him. Maybe he paid something for some of the boxes. Who knows? You don't know. I don't know. You're never going to know. All you do know is that a small percentage of this massive amount of property was on his property, and he shouldn't have had it. Yes, that deprived Mr. Kirkbride of possession of it. Granted, that's a given. And I think you can realistically go back there and say, we don't even think it's $2,500. And therefore you get to not guilty. But if you think it's more than 2,500, what is the next level up? Over 30,000. Folks, you can't get past $30,000, right? Why was all that stuff in the yard? There was nothing of value there. It was papers. There was mementos that were very valuable to him sentimentally, but of actual value. And the jury charge describes for you, well, how was that figured out? How do you figure out what value is? It gives you the definition. The thing that I think is most important to look at is when you go back there and you're looking at the different categories and you're looking at the evidence, how do we find beyond a reasonable doubt that the state has proven all of these things? You're going to go in circles because you're not going to find it. There's no eyewitnesses. There's no confessions. There's no admissions. The truck's not there, the trailer's not there, and the vast majority of items that you see in the insurance list is not there. There's a handful of things. And he's taking the blame for whoever was involved in this case. And that's fine. How did this case become such a big deal besides the sad story that's behind it? Mr. Kirkbride wasn't gonna let it go. He's calling the police. He talked to the chief of police. He talked to the mayor. And all of a sudden, everybody's scrambling. Let's get on the ball. It came out in the news. He even said it. After this is over, you could probably go still find it on ksat.com or all these other places. He made people move because they weren't doing right by him. Understandable. He lost a lifetime's worth of things. I get all of that. But you don't just patch together a case and throw the patsy and say, okay, Mr. Kirkbride, we took care of it. We arrested Mr. Rosano. But even Mr. Kirkbride would tell you, yeah, but where's all this stuff? He doesn't have all that stuff. You don't even have any proof that he ever did. It's a sad situation. But if you're true to your oath and you look at the case based on what was presented to you, look at the documents, look at the insurance claim, look at the pictures of a bunch of empty boxes and ruffled things and mementos, not of value, you can never get past $30,000, folks. You just can't. So if you feel that you have to make a finding of guilt, that's the only category that makes any sense. But I would still ask you to look at, is this search legit? Under these circumstances, the way the law is written, as described to you in the charge. And if you're honest, you're going to say, no, that doesn't fly either. And you're going to have to make a finding of not guilty because the evidence was illegally obtained. So please consider all of those things and please honor your oath. And don't feel like by not giving the state the verdict that somehow you're disrespecting or minimizing Mr. Kirkbride's loss, because nobody's doing that. We're just asking you to do what you promised you would do when you took your oath. Thank you.
All right, state.
I just want to talk to you, remind you of a few things Daniel and I have been talking to you about since jury selection. So our burden in this case is beyond a reasonable doubt. So I'm asking you to not leave your common sense on the courthouse steps. Okay, so there's some things that Mr. Martinez talked about that may be possible, right? And I want you to remember the photo of the dog in the kitchen. And remember that just because something's possible does not make it reasonable. Okay, so it's possible a tornado picked up all this stuff and dropped it in Mr. Lozano's backyard, right? That's a possibility, right? But that's not a reasonable possibility. The first three items, I don't think we're in dispute here. This happened in Bear County. The date's not in dispute. Jose Lozano, the defendant, that's not in dispute. With intent to bribe Terry Kirkbride, the owner of the property, we heard from Mr. Kirkbride up here on the stand. I don't think that's in dispute. I want to talk to you about the mental state. Intentionally acted with a conscious objective or desire to cause the result. And we talked about this in jury selection, right? That's the legal definition, but all we're talking about is you took something that wasn't yours and you knew you did it. You did it on purpose. How do we prove mental state? Mental states can be inferred from acts, words, and conduct of the accused. And so in this case, we had heard testimony from Edith Serrano, who's the mother of the defendant's children. At the time they lived together. She said Jose told her, Jose brought the stuff to the house. He told me he bought the stuff. The next element we have to meet here is unlawfully, without effective consent, appropriated the property. Okay, so who did we hear from? We heard from CSI Gonzalez. He collected the fingerprints from the trailer. We also heard from the fingerprint examiner, Ms. Serenil, who matched the fingerprints to this defendant, Jose Lozano. And you all heard, she also took his fingerprints earlier in court this week. The fingerprint that was found on the trailer matched this defendant. This is the laundry list that we went through, and I'm sorry that part of this process was we had to go through so many photos, but I wanted you to see the scope of what we're talking about here. We're talking about a lot of stuff. These folks had packed up everything they owned to move cross country, and so that's why we had to go through all those photos. But those are the laundry list of things that we're talking about. And sorry, that's what we're going through. So that's the photos and the list. The list was admitted as State's Exhibit 48, and that'll go back there with you. You'll have the opportunity to look that over. And then the valuation. So there's been some talk about the valuation. There's been testimony from Mr. Kirkbride. You saw that list. You'll see that other list from USAA. And what I want to draw your attention to on Defense Exhibit 2, which is this documentation for USAA, in the first column, USAA calls the recoverable valuation of the property at $450,000, and then they depreciate that amount, and they settled at an amount after you take out depreciation less than $300,000. But if any of y'all have dealt with insurance companies before, you know that if you insure something for $100, it'd be extremely rare to get the $100 back. So they settled with the insurance company. But I believe the testimony supports the contention that this theft was of property worth over $300,000. We talked about this in jury selection. We talked about if there's a theft and you recover some of your property, is there still a theft? And none of y'all had a problem with that, right? I mean, there's this idea that, you know, Daniel gets his bike stolen, but he gets his bike back. That's not a theft, right? No, that's still a theft. There was still a theft, even if you got some of your bike back, right? And why should we care, right? Well, this is your opportunity to tell the community that this type of crime should not be tolerated. Don't make this okay in Bear County. Don't make this okay in San Antonio. This is y'all's community. And this is your opportunity to protect your community. So let's talk about responsibility in this case. Who had responsibility in this case? The defendant, Jose Lozano. His fingerprint was found on the trailer. This property was found in his yard. Property was found in his house. It's Terry's property in Mr. Lozano's yard and in his house. He has responsibility in this case. You are the exclusive judges of the credibility of the witnesses. So you get to decide, is it reasonable, is it credible that Mr. Lozano bought these items? So does it make sense to y'all that he spent money that he worked for on these items and then left them outside for nearly 3 weeks? Some of these items got ruined by the elements. I'm glad it rained last night because maybe that'll aid you guys in your deliberations. If you bought something for money are you gonna leave it outside to be potentially, and in this case, in actuality, to be ruined by the elements, be ruined by rain? These are some of the items that were found outside the house. This is. Oh, Daniel, what are you gonna do? Something going on here. Let me see. So we got, this is a picture of the camper shell. That Mr. Kirkbride identified from the witness stand. That's his camper shell. Which is also in evidence. There you go, thanks. And this is what the police saw from the backyard of the side of the yard. So there's the front of the house, this is the side of the yard. So the police get back there, they can see all this stuff back there. And they've already, keep in mind, this is after they've already matched up the fingerprint from the trailer. They've identified a suspect. They go outside, they're standing on the side of the house and they say like, that looks like a bunch of stuff that was stolen from some folks that were moved, okay? So at that point, they go and get the warrant. They go and get the warrant from a detached neutral magistrate, and then they search the backyard and they search the house legally. But does it make sense to y'all that Mr. Lozano would have spent money on these items? I mean, this is a lot of stuff here. Does it make sense to y'all that you would spend your own hard-earned money on something and then leave it outside for almost 3 weeks to be ruined by the elements, be ruined by rain? That doesn't make any sense. And then you can see these items. This has got Mr. Kirkbride's last name on his bags here, his military bags here. And so it doesn't make sense to me that someone would go out and buy this stuff, somebody else's name on it, and leave it unpacked in their backyard like that. You see here, this is Mr. Kirkbride's documentation and handbook for his truck that was also stolen. And to me, you could make reasonable assumptions from the evidence. And the reasonable assumption that I'm making from this evidence is that at one point, Mr. Lozano had access to that truck because the book is in his backyard. Here's some more of Mr. Kirkbride's property. You can see his name right there. This is one of the many pictures of Mr. Kirkbride's military, one of his medals. And I put this up there. There's more in evidence and there's more on that CD that we answered. And you'll have the opportunity to look at that when you're back there deliberating. But these are the types of things that were left outside in the elements to be ruined. But does it make sense to y'all that somebody would spend money on this and just leave it in the backyard? This is a box that's got Mr. Kirkbride's name and address on it. That's something that was left in the backyard. And then we got the property that was inside the house. So we talked about this cat statue. Mr. Kirkbride identified that. These are some pocket knives. Mr. Kirkbride identified that at least one of those is a family heirloom. We've got a vehicle here. This is that statue that Mr. Kirkbride described to us. So I just want y'all to keep in mind the sheer scope of the amount of stuff we're talking about. This is a 24-foot trailer. That the way I was thinking about it is they loaded it like it was a game of Tetris. Okay, every square inch of that thing was stacked loaded, and then it was gone. And so the police get the fingerprint on the trailer. This is the picture of it. And if you look at the screen here, on that diagram, in about the middle of it, it says, I don't know if this is going to display it, but it's not going to work on the television screen, but it says front and then an arrow. So where they recovered that fingerprint is where you would unhook the trailer from the back of a truck. Y'all can make reasonable inferences from the evidence. So a reasonable inference from this evidence, this is a photo of the fingerprint card, which will also go back with y'all. You'll have an opportunity to look at that in person if you'd like. But a reasonable inference from this evidence, when you take the book from the F-150, you take all the camper shell that's in the backyard, you take all the items that was emptied out of the trailer. The reasonable inference is Mr. Lozano took that truck, took the trailer to his house, emptied it, took the cover off the camper, left that in the backyard, and then dumped the empty trailer about 20 minutes away from his house. That's a reasonable inference from the evidence that's in front of him. These are the fingerprints that Miss Sarah Neal took earlier this week of the defendant that matched the fingerprint that was found on the trailer. It's a palm print. This is because it was a palm print that was found. So this is a photo of Mr. Kirkbride in his trailer. And as you can see, it's empty by the time this is on the December 5th. So the trailer is taken on the 4th, and it's found less than 24 hours later, empty. It's in this condition. The fingerprint's already on it at that point. But the stuff's gone. Because the stuff is in Mr. Lozano's backyard. Because Mr. Lozano stole it. These are all reasonable inferences that you can make from the evidence. So one thing that Mr. Martinez said that I agree with is that thieves steal things in order to sell them. And so I believe that is part of the reason why there wasn't a lot of valuable items found in Mr. Lozano's backyard. He empties that trailer into the backyard, picks out the stuff that he wants for his house, sells the valuable items, and by the time police got there, what is left is of little monetary value. But if you remember the last question I asked Mr. Kirkbride yesterday, I asked him, what is the worst thing? What is the thing you missed the most that was taken? And he said, it's the things that I can't replace. The photos, the military stuff, the items that he inherited that he hoped to one day pass on to his children and to his grandchildren. And those things are gone. And they were worth nothing in monetary value, nothing to Mr. Lozano. But they were worth a lot to Mr. Kirkbride. They were worth a lot to his family. It would have meant a lot to his children. It would have meant a lot to his grandchildren. So I'd ask you to think about that when you're back there deliberating.
Check your argument to ask the jury to disregard the law. Value is determined based on definitions given, not what the eventual value is. That's not the law.
All right, ladies and gentlemen, the court gives you the law and the law is in the jury charge. Does everyone understand? All right, you may continue.
And I'm asking you to hold the defendant, Mr. Lozano, responsible for his actions and find him guilty of theft over $300,000.
Thank you. All right, ladies and gentlemen, you've heard all the evidence that you're going to hear in this case. Deputy Laura is going to take you back to the jury room. All right, so everyone, Deputy Laura informed me that they buzzed for a verdict.
Okay.
So she's going to line them up. Are both parties ready?
Yes, ma'am.
All right, everyone, please be seated. All right, ladies and gentlemen, the court has been informed that you've reached a verdict. Is that correct? And is that verdict unanimous? All right, if you'll hand the charge to Deputy Laura for me, please. All right, the verdict form reads, we, the jury, find the defendant, Jose Lozano, guilty of the offense of theft, $300,000 or more as charged in the indictment. You may be seated. Does anyone wish to have the jurors polled?
Yes.
Ladies and gentlemen, I'm going to ask you whether or not this is your verdict. If this is your verdict, I would like for you to answer yes. Does everyone understand? We'll start on the front row at the end. Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict?
Yes, ma'am.
Is this your verdict? We'll start on the back end. Is this your verdict? 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 Is this your verdict?
Yes.
All right, thank you all so much. what's going to end up happening now is I'm going to send you all back to the jury room and I'll come back and speak with you briefly. All right, everyone, please rise for the jurors. All right, everyone, please be seated. All right, so Mr. Lozano, the jury has found you guilty. Defense, you stated that you would come to the court for punishment. Is that correct?
Yes, sure.
All right, so what we're going to do is we're going to reset this so that I can get a PSI report, and that will tell me some more things about you and help me consider what to do as far as punishment. Do you understand?
Yes, Your Honor.
Right. So I believe they are 6 weeks out. So let me see. And if the date I choose, if something that doesn't work with your calendar, because I know, Mr. Martinez, that you have jury trials in other counties that are scheduled. And I'm going to set it for April 18th. And if for any reason that it can be done sooner than that, we'll do it sooner than that. Yeah. And that will be a PSI. Is there TAP evaluation needed?
I haven't seen anything in the file or anything else that suggests that, Judge, or in his history, but obviously, of course.
All right, I'll order a TAP evaluation. Is there a request that he be in custody or no?
There is, Your Honor, this is a first degree felony, so and I believe he's had some trouble on bond reporting, so we are asking to be taken into custody, Your Honor.
All right, with regards to the issue of whether or not there's been some concerns about bond, have there been any bond issues?
I'm unaware of that, Judge, but I'm not sure I've been on the case.
So it's just hired a lawyer that he got, paid and got
Yeah,
out.
previously. I'm not sure why we changed, but somehow I got this.
We can confirm the dates, Your Honor, but when he was arrested for this offense, it was because he had failed to appear, I believe.
And it was an affidavit of surety back in August of 21.
All right,
Well, as you know, Judge, bonds may get off bonds for all kinds of reasons. Business is non-compliant with court orders. It could be that he got sideways with them for whatever reason. But like I said, I wasn't on the case at the time. I know that he's always been here, been here every day for trial on time. He has a great interest in seeing this case to a conclusion. I'm anticipating an appeal, a request for an appeal bond, so I'm sure he want to be on his best behavior in order to get that.
all right, so this is what the court is going to do, because it appears that the defense may need to prepare argument as to why he shouldn't be in custody. So I'm going to give you all a chance to confer and state for you a chance to look to see if there's a reason why he shouldn't remain on bond, and defense give you a chance to look at what they have the court. All right. So he's going to remain here in the courtroom and he's not allowed to leave the courtroom. I'm going to go talk to the jurors briefly. If anyone else would wish to talk to the jurors, you're more than welcome to do so. All right, everyone, please have a seat. If you're not on this case, court is calling 2021 CR 7016, State of Texas versus Jose Lozano. Can I have the parties announced for the record for the state?
Looking for the state, Your Honor.
Defense?
Raymond Martinez from Mr. Lozano.
And are you Mr. Lozano? All right, we are here for sentencing. A jury found you guilty. Just one moment. And they found you guilty of the offense of theft, $300,000 or more as charged in the indictment. Have both parties had a chance to review the PSI report? State.
We have, Your Honor.
Defense.
Yes, Your Honor.
Any corrections or additions to the PSI report? State.
No, Your Honor.
Defense.
No, Your Honor.
All right. State, what are you requesting?
Your Honor, we're asking that you sentence the defendant to 15 years in the prison.
All right. And the reason?
Your Honor, the defendant was convicted of a first-degree felony offense in this case. Reading the TAP evaluation, he's shown no remorse for his actions. He doesn't say this was the result of being under the influence of drugs or alcohol. His story about how he says this happens is just not credible. It doesn't jive with the evidence that we saw at trial. He says that someone offered to sell him $300 worth of items, over $300 worth of items for $600 to $800. He says his friend brought the trailer to him. The evidence that was elicited at trial indicated that a window of the truck was broken. So it's pretty clear to me that he knew these items were, the very least he knew these items were stolen. But Your Honor, what he's convicted of is theft. And I guess the other part of this, the TAP evaluation, they talked about his home life a little bit. He says he has regular contact with all his kids, but evidence elicited at the trial was he's not paying any kind of child support to Edith Serrano. That was one of the victims, you may recall, Your Honor. Or I'm sorry, one of the witnesses at the trial, Your Honor. I just want to, I know you were presided over this case, Judge, so you remember the testimony, but Terry Kirkbride and his wife are moving from California to Florida, and they lost almost everything as a result of this theft, Your Honor. But what Terry said on the stand is what really stuck with me. And what he said is the hardest part about this is that he lost things in this theft as a result of this theft, as a result of the actions of the defendant that cannot be replaced. So the hardest part of that for him were the photos that are just gone forever. The things that he inherited, the things that his wife inherited, they're gone forever. Items from his military career that are gone forever, damaged or lost. And so that's what I want to emphasize to the court. And the other part of the thing I want to emphasize to the court, Your Honor, is we're asking for this sentence to protect the community from these types of thefts. This property crime, I think, especially folks who are involved in the criminal justice system, we can get sort of jaded and think, well, nobody died, right? But these crimes are very serious, and this is the victims in this case lost nearly everything that they own. And so, Your Honor, we're asking that you protect the community from these types of crimes and sentence the defendant to 15 years in the prison.
All right, defense.
Judge, if the court recall from the facts of the case, I think Mr. Lozano's explanation is perfectly plausible. There was absolutely no evidence presented by the state in the trial of the case that he was present when that truck was stolen, or that he ever drove that truck, ever had contact with that truck, it was ever on his property. His suggestion that the guy brought the trailer to him to see if he wanted to buy it is consistent with somebody who did steal that property, trying to go and pawn it off on people. Him paying $600 or $800 for what was the contents is because all the valuables were already gone. All that was left was a bunch of stuff that after whoever stole it poured through it. He admitted, yes, my print is on the trailer because he showed it to me, and he wanted more money than I could afford, and so I didn't buy it. He offered me the other things that were there. The complainant specifically testified in his testimony, the things that were at Mr. Lozano's property that they recovered were of little or no value, right? If you look at the PSI report, when they go to the restitution, it says approximately $300,000. How can you approximate that when he's already been found guilty by a jury? Well, this court knows why. It's because her math was a mess. The complainant testified in the trial of the case that he agreed in writing a contractual agreement with the insurance company to settle for $240,000. The theft statute is very, very clear. It's the value of the property at the time it's stolen, not what you paid for it years before. So when you read their exhibits, and the jury obviously never did, they put no attention to the real evidence in the case. They felt bad for the complainants. I feel bad. We all do. They suffered a great loss, but they didn't prove he was the one who did it. They proved that he was a party to being in possession of some of the stolen property. That's why we had a jury charge all the way down to a state jail. That was the appropriate charge. This case is ripe and full of appeal issues, especially on the issue of the value and sufficiency of evidence. This case does not merit a day in prison. I get it. It's a big loss. But if you look at the exhibits, and I was going to bring it to you, but it's in the court's file or court board's file. USA went through an exhaustive list, and he says I spent months and I kept updating it, telling them all the things that I lost. They put the retail value, They depreciated it down to the actual cash value at the time of the loss, right? He signs an agreement, accepts the check saying $240,000. And that included the truck.
All right, so just so parties know, I'm not going behind the jury's verdict.
I'm not asking you to,
Yeah, all
I'm just saying the punishment should fit the crime.
Okay.
The jury did what they did, and that's for another court to look at, whether there was sufficient evidence for their verdict. But my suggestion is, if they've proven that my guy drove off with the truck and the trailer and he had gotten rid of everything, I can see that this is a different case. There's absolutely no evidence that was presented to suggest that. And his explanation fits squarely within the facts that were presented in this case. So I get it that there's restitution. My client is going to have a lifetime consequence because of his resident status of potentially being excluded from this country. So he is going to get punished severely by this court and probably another one. So all that being said, Judge, we'd ask the court to sentence him to a term of probation. We'll pay restitution to their number as best he can, as long as he can. But that's the appropriate sentence. If we're going to start locking up every person who goes to a flea market and those people that come into property illegally and they get it in their possession, we're going to start sending them all to prison. We don't have a big enough jail for that, Judge.
All right. Is there anything you wish to say?
Yes.
All right, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, and make sure you keep your voice up so the court reporter can hear. Who's the name of the friend that gave you these items?
What was the name? I don't know his name. They called him.
Well, I mean, you say he's your friend,
Well, yeah, but
and you say you received a phone call from a friend.
yes, should have wrote it down.
All right, so here's my other question. The items, because there were some items that were related to his military career. When you saw the name of a person's name on military paperwork, what did you think?
At the point already, I had the stuff in my house. I didn't know what to do with it, no more. It was there. I bought it. It was in boxes when I bought it. By the time I got to open it, I saw the stuff.
So how much money did you pay for this stuff?
About 800, whatever was in the trailer, when I got it off, about 800 and $900.
Did you look through everything before you paid 800 or 900?
Boxes.
So you just take a box's sight unseen, sort of like Storage Wars?
Oh, yeah.
All right. And so you don't know your friend's name who phoned you. According to you, it says that you were home asleep on this date and you received a phone call from a friend.
They call him Chaparro, but I out of the top of my head, I can't remember his name right now. I'm
Okay.
sorry.
Oh, no problem. I just wanted that cleared up. All right, this is what the court is going to do. Court is going to sentence you to 6 years in the prison, give you credit for any time served. With regards to the amount, the court does not deal in approximations. So for the court, there is no restitution because there is nothing here to suggest a restitution amount. It just says approximately $300,000. There's nothing I can do with that. And this trial was on March 21st. I'm sorry, just one moment. Yes, March 2024. So by that time, there should have been some amount to the court. So I'll give you credit for any time served. Is there anything else with regards to sentencing, state?
Judge, is the defendant's birthday May 1st, 1998? Is that right?
You can ask him.
Okay. Is that your birthday, sir? May 1st, 1998?
Yeah.
And Judge, would you incorporate the evidence at trial as to the value? Would that be something you'd be willing to do?
No, because again, the amount that's listed in the PSI report is approximately $300,000. And then defense counsel is correct with the amount that the complainant settled for, And I know how insurance companies do sometimes.
Probably
The amount, yeah, the amount the insurance company settled for was $240,000. So this is where we are.
If I could, just one last thing on the record. I just wanted the court to be aware, the record to be clear, that that approximation comes from the complainant. The PSI officer called the complainant to ask him that number, and that was his response,
Yes.
even after his testimony that was presented to the court.
I'm not ordering restitution unless there is some sort of deductible, which the court has not received any information on a deductible amount. So the court will sentence you to 6 years in the prison and give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honor, we just have victim impact fees.
I do, Judge.
Yes.
We will be filing notice of appeal and request for an appeal bond. Do you want to take that up today or?
Oh, you have to file you'll have to file the motion and the court will take that up. So if you could have him fill out the trial court certification.
Well, they're gonna be filed today. That's why I'm asking if he could be kept in court today so we can address it, or do you want us to set another
It's gonna
hearing?
have to be another date. All right. Once if you could have him do the trial court certification, so I could do that now, please.
Do my magic moves backwards.
Yes.
She wants it.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? All right, you have a right to an appeal as this was a jury trial. And counsel, once you file that motion, Ms. Ferguson will give you a date.
Yes, sir.
All right, you said there's impact, brief impact.
Yes, ma'am.
All right. Are the parties here on Lozano? If you could start your video, please. Who's going to be the person?
It's Terry Kirkbride, Your Honor.
All right. Mr. Kirkbride.
Yes.
All right, you may begin with your impact statement.
Okay, I had no idea what to expect in this matter, but I see the sentencing's already been done. I'll just try to keep it short. I think the court's already heard most of our story, but I'll just go down the quick history. I mean, when we made our decision to move to Florida, it was to be near kids and grandkids. It was a pretty tough decision. I lived in California all my life up to that point. Sold our home, gave away pretty much all of our possessions that could be replaced, like furniture, refrigerators, that type of thing. All of our most precious items were packed up very carefully. It took us almost 3 months to get everything properly packed and wrapped. And I bought a 24-foot enclosed trailer, and that's where we packed everything in. On our journey to our joyous move to Florida to start a new life, we made it as far as San Antonio. And of course, from that moment forward, December 4th forward, it's just like our world was turned upside down. It derailed our whole joy of the move. And what was supposed to be looking for a home right away turned into almost an 8-month endeavor because we were dealing with all of the aftermath of the theft. I'm a combat veteran. One of my diagnoses is PTSD. So I was already dealing with that. And then this just totally derailed me and my wife and left us kind of in this state of like, what next? As we put the pieces together, keep in mind, it was 3 years, 3 months from the time of the theft to the time of the trial. And they had some 22, 23 resets. Each one of those resets represented to us is we had to juggle our lives around the schedule of the court. We gave up family vacations, gave up visiting sick family members. We did a lot of things during those 3.5 years, 3 years, 3 months that just kept this thing going. And now we're here at the final final part of the sentencing and all that. And I feel for both sides. I feel for Mr. Lozano and how this must be for him. But I also got to understand what it was like for us. These weren't just things that you go to the store and buy. This was our life. My wife is a Native American studies. She had all of her research that was in those boxes that are gone, all of my VA records, all of our photographs of our family from the past, videos of the kids, all those things that cannot be replaced, along with all my military accolades that are gone. The impact was great. And I am glad that we're finally at a point for us anyways, where we can just kind of turn the page. I think that's enough said.
All right, thank you. And Deputy, you can take him into custody.